All right, people. I think we're live. Let me just get perfectly centered here. Some last minute crises because I left a certain adapter thing. Is that bad? It's better. Okay. And now I hear myself in the background. Hold on, mute that and pause that. All right, here we go. We're live. Good. Yeah, minor disasters because I left the little adapter thing for the mic and the camera not here. And so I'm now doing this off an old computer, which has the USB port thingies because the new Mac or the Mac Air Pro, whatever I have, only has those fire cable things. And then the thing that I used wasn't working properly. Okay, so all that to say is I was planning on having a little graphic to run through an article. Instead, I don't think I'm going to be able to pull up the article. Double audio. Oh, no, it's over now, the double audio. Because in this introductory Viva Rant, it's going to go over a couple of articles that I just discovered that have irritated is not the word. Irritated is not the word. Enraged. And I'm always reminded of, it's Nietzsche, who says, in fighting monsters, be careful not to become a monster, because when you stare into the abyss stares back. Don't become a monster ever in life. Some people call it being a sissy, and some people call it being Canadian. Kill them with kindness. Every now and again, a sassy, snarky tweet. So let's have the rant of the week. I'm going to drink some Monticello, Saint-Brigitte de Laval, sur Laval, whatever. I don't know what this is. It's carbonated water. I'll drink it in a bit. I missed a bunch of super chats already, and I'm sorry, and I can't find them now because it's whatever. Is this available on Rumble? Thank you for whoever said that. We're live streaming simultaneously on Rumble. Rumble, for the time being, I don't think you can comment yet. And a lot of people have issues with Rumble in that they ask for a cell number in order to sign up for an account, which I understand. The world's never going to be perfect. So you deal with the perks and the pitfalls of the various beasts with which you work. Okay. First things first, I'm going to miss super chats, and don't get miffed if I'm going to. 30% of the super chat goes to YouTube. I am currently looking into Streamlabs, which is the less beast feeding alternative, but we'll see if we can get there. Let me just bring up two super chats while I'm here. Please ask Barnes what the difference between Nike Lil Nas lawsuit and Hennessy performing altering 4G. We will. We're going to get into it. We're talking about Lil Nas Satan shoes tonight. We're talking about a lot of stuff, but let me get the rage off first. There was, this is Chet Chisholm says, this is not criticism of Miss Hansen's abilities as an EMT, but if she approached me, paramedic, the same way, I would not have allowed her to access the PT or permitted her to accompany in the ambulance. Okay, we're going to get into that as well. Here's the rant and the rave and starting. There was an article that I just read because a daycare professional, whatever we call them, a daycare professional, not necessarily daycare, but child teaching thing professional, came up to me and said, Viva, or Dave, which is my real name, did you read the article about the defective face masks I don't even know if it's defective or if it's just, the way these were manufactured, that apparently people are inhaling some carbon fiber thing, whatever's in the mask to filter out the mask. I said, no, I haven't heard about it. Why do you ask? And she says, well, daycare professionals and students and kids have been wearing them, a specific model, for months, and they've just been recalled because they found out that people are inhaling particulate particles, carbon fiber particles from the masks. And so I went and I looked it up. So I'm going to take the super chat down. And I looked it up. And apparently millions in Quebec have been recalled, or people have been told to stop using them because of potential toxicity of these face masks. And I got enraged because things have been weaponized to the point where, when you ask questions, you get demonized, and you get demonized as an anti-whatever. They call them anti-climate people, anti-science, anti-maskers, anti-vaxxers. It's like the second you ask questions, you become anti. And I have never been anti-masker, and I've never been anti-vaxxer, and there's no but to that. I've never been it. I just have an objection to them becoming required by law for a number of reasons. And this would be one of them, where when you are not allowed to question things, it's as though everything bypasses quality control, except it bypasses intellectual quality control. And dare you question, well, is this good? How dare you? You want Granny to pass away. And now, a year later, we have been finding out, and we don't exactly know how long the government agencies knew of the problem, that these masks, people were inhaling particle matter of whatever is in the mask. And teachers and kids were complaining about it because apparently it felt like they were inhaling cat hair while they were wearing these things. And you dare ask the questions, you're deemed an anti-masker. Dare ask questions about the vaccines, you're called an anti-vaxxer. And I actually had this discussion with someone, and I said, I'm not anti-vaxxer. I just don't think everybody needs to take all the vaccines and whatever they're imposing at any point in time blindly. And the person unironically asked me, well, doesn't that make you an anti-vaxxer? It's like, if you don't want to take all of them, it doesn't mean you're an anti-vaxxer. If you ask questions about things, it doesn't mean you're an anti-vaxxer. I got a tetanus shot the day I cut my finger metal detecting. And now Canada recently, it's CBC, by the way. So I wish I could pull these articles up, but if you follow me on Twitter and if you're a member in Locals, I've shared them there. CBC said, there's a particular vaccine that Canada is now suspending application of or injection of to people under 55 because they've noticed, I think in Europe, there were some cases of blood clots. And so you're an anti-masker if you say maybe it shouldn't be required by law and maybe I have a few questions. You're an anti-vaxxer if you say maybe I'd like to ask a few questions and maybe I'd like to have informed consent. God forbid what was, under the Geneva Convention, not the Geneva Convention, what I'm talking about, the Nuremberg Convention. So that's my rant. And now they're saying, okay, we'll suspend this vaccine for people under 55 because of certain risks. Now the government says, recall. Don't use these masks and put them in a safe place. The masks that we were compelling you by law, not just compelling, professionals, teachers, which is one thing, children to wear these things. So they might have been inhaling some inorganic fibers for the last 8 months because the government made it a law to do this. And what put me over the edge of my enraging rant, Point Curation, welcome. Point Curation, I believe, made that painting right back there, which has now found its place in the backdrop. What put me over the top? François Legault, our premier, for those of you who don't know. Full disclosure, I voted for François Legault. I voted for La Coalition Avenir de Québec last election, 2018. Like my grandmother used to say, I voted for them twice, the first and the last time. His tweets have just been glorious ivory tower. Look at me, I'm a person of the people, I'm a man of the people. He tweeted today, or yesterday, I forget which, second anniversary of celebrating Easter differently. But that doesn't stop you from spoiling yourself and having some chocolate. And then he's a picture of him close to some other person, I don't know who she was, in a store buying chocolate. I don't know what the heck is going on. And everything about that blew my mind in terms of its, what's the word I'm looking for? Tone deafness and absolute in-your-face, I guess ostentatious, that's not the right word, you know what I mean? Everything about it. As if to celebrate the second Easter where people are not allowed to celebrate what is to some the holiest day of the year. As if it's something to celebrate. Hey, second anniversary of celebrating Easter in a way that is not religious for some, and that is a total violation of religious and civil freedoms for others. Second anniversary. And, it's only going to be a matter of time before this becomes, it's never going to happen. Touch wood, it never happens. It's only going to be a matter of time before this is, hey, 10 years straight. This year, the supreme leader, the benevolent leader will allow you to celebrate Easter the way any free and civil society that has any respect for the most fundamental religious freedoms will allow you to, the way you're supposed to. And he's celebrating it like it's days at work without an accident, like it's an accomplishment to have violated year over year our most fundamental freedoms. And then to say, go eat chocolate, as if that's what Easter's about. Sorry, I'm shouting. As if in his mind, that's what Easter is about to people who celebrate Easter, eating chocolates. I'm not religious. No, but But I am now beginning to fully appreciate the value of religion and what happens when a government literally thinks they can replace someone's God. Tell them how to celebrate their most basic religious fundamental holidays, and then to pretend it's about eating chocolate. And setting aside the whole obesity being one of the most radically contributing factors to hospitalization and COVID problems. This premier who's been locking us down, over sanitation, stay in your houses, don't get sunlight, don't get exercise, now is telling you, spoil yourselves this Easter and have some chocolate. As if that's what Easter's about to the people who want to celebrate Easter. Oh, and then the other thing that pushed me over the edge, I didn't know it was news. I'm raging and ranting to somebody in the park. And they said, yeah, did you hear your premier selling his mansion for $5 million? And I was like, no, is this public information? Because I'm not about disclosing any private information. It's public. It said it's been everywhere. It's been an MTL blog, which is a Montreal thing, everywhere. He's selling his house for $5 million. Admittedly, he's been there for 20 plus years, and he bought it for 1 point some odd million in 98. Or that's what they think, at least. Our premier, who has been restricting the most basic civil liberties, shuttering businesses, giving people a stipend while everything we once knew of a free and democratic society has been wiped out, is selling his $5 million mansion, which has, incidentally, according to the listing, Joseph Montanaro is the agent. Apparently, I know him. He's very, very, very good agent. It has a pool and a cinema. My goodness, being locked down in a house with a pool and a cinema must be a little less hard than being locked down in a 1.5 apartment in downtown Montreal, where you don't necessarily even have a balcony to sit on. Obviously, my biggest blessing in all of this lockdown is we have a treadmill in the basement. If I didn't have the treadmill in the basement in winter, okay, I missed a bunch of super chats with that. Let me just see. I see Robert, and Robert, I think, is laughing. Sorry, guys. That's the rant. Thus ends the rant. It's we are living in a world where political incompetence gets rewarded, where the politicians who are destroying and crippling and punishing the lowly citizenry are so far detached, they have no idea. And even if they have an idea and they can empathize in the trivial way politicians empathize, they do not appreciate what people are going through. And they don't appreciate what we're going through. And I said this in one of the tweets. Our leaders have destroyed our rights, destroyed our economy, destroyed our family units, destroyed social cohesion, and at the same time, over the last year, actually failed to protect the most vulnerable people. Let them eat chocolate cake. Let them eat Easter eggs while I sell a $5 million mansion. And the reason in one of the articles why he's listing it, it's too big. It's too much to take care of. Did you see the absolute boss level minister who showed it? We're going to talk about it at a health inspector and cops at a church somewhere in Canada, Calgary. His name is Artur Pawlowski. More courage than me. I'm not even going to compare it to others. More courage than me. First of all, I wouldn't have used the N word or the Gestapo word. That detracts from it a bit, but my goodness, courage. In 2015, Ontario Nurses Association fought forced flu vaccines and mask wearing and won. The argument against masks, they don't work. Now, and this is not medical or legal advice. I know people are going to complain about this. I'm just reading a super chat. Now they advocate for unaccountable bureaucrats forcing everyone to wear them. Happy Easter. Thank you very much, Tara. And this is Tara. Sorry, Tara. This is not an endorsement of what Tara wrote. I know the limits of my knowledge. I just know that I saw 2 articles in the last 2 weeks which have enraged me because you get branded an anti-Xer because you dare ask questions, and then lo and behold, some small problems, some things here and there, some inorganic particulate matter that your children have been inhaling potentially for the last 6 months. Okay, let's see this. Love you, Viva, but I'm surprised it blew your mind. This is how they've acted from day one. No, I started slowly, but election season cannot come soon enough. Okay, so with that said, no legal advice in this podcast. It is in podcast format the day after. It's also on Rumble the day after, although it's live on Rumble now. What else? After the party, there's some chat going on at Locals. I'm going to bring Barnes in for that. My rant to Barnes, 0.8 seconds from the MS UCLA. Pick showing you I'm better at basketball picks when I only watch hockey. Okay. With that said, oh, by the way, and everyone, go share the link because YouTube sometimes gives notifications like 2 days later. Let's bring it in. The Barnes. Robert, can I hear you?
Good.
Yes. Okay, I can hear you. Let me bring up my volume just a touch. That's the wrong way. Okay, Robert, I'm sorry you had to see me like that. I've calmed down now.
I would say, my house might have a pool and a cinema, so.
Well, but
I don't think it's worth $5 million, and I haven't locked anybody down recently.
That's the issue. I want people to appreciate that. I'm not anti-rich. I'm not anti-wealth. I'm anti-hypocrisy. It's, when I was winding down my litigation practice and we had employees, I didn't dare say, hey guys, you're gonna suffer because of my decision here. Those employees got paid before I did, and I sort of went into a minor shareholder loan debt so that I could do what I wanted to do, but they got paid first. This is not anti-wealth. This is anti-hypocrisy. If you're wealthy and you have a nice house, good. If you're not telling people to shut up and do what the government says at the same time, that's when I have the problem. It's François Legault telling you, it's okay. You don't celebrate Easter. Stay home. Go for a walk. He actually tweeted, go for a walk yesterday. Like, go for a hike. But meanwhile, I have a cinema and a pool in my house. So me being locked down for a year and me being in curfew is not as bad as you being in curfew, you lowly peasants. Okay, sorry. So it's not a critique of wealth. There's nothing wrong with being wealthy. There's something wrong with being a hypocrite who is sheltered by their wealth while telling other people to do something that they themselves are not doing and which doesn't affect them the same way it affects others that they're telling to do. Okay, Robert, what are we talking about tonight? What's on the menu? It's a big one. We got Chauvin. We have got, oh gosh, we got Chauvin. We got the NCAA. We've got cheerleaders who are going to the Supreme Court. Supreme Court doesn't have time to hear election lawsuits, but they can hear a cheerleader free speech issue, which is a very important one. Oh God, I'm going to forget the rest, but let's just start. I mean, everybody wants to know the latest updates in Chauvin. Spend a bit of time on that. Then I'm going to go discreetly look at my list and we'll get onto the others. Chauvin update. Okay, I mean, I guess the update now is we've actually had a few days of trial and we've had some meaningful witnesses and we've had some meaningful testimony. Chauvin's girlfriend, or not Chauvin, I'm sorry, George Floyd, the now deceased George Floyd's, I guess, his girlfriend, 2 EMTs, a sergeant who have testified. I guess to summarize the testimony, one of the sergeants said that the force Derek Chauvin applied to George Floyd was completely unnecessary. This, according to Sarah Sidner, was one of the great moments for the prosecution. The defense brought up the drug use, brought up the overdose, the near overdose a year back. One thing before we even get started, and I don't understand the impact of this, it was a tweet going around. The defense brought up the fact that George Floyd's girlfriend, her nickname was Mama. And I don't know why. I don't know if they were making fun. And if they're making fun, I don't care. Or I don't know if that had evidentiary relevance. Do you know if there was any reason for that?
It's that when Floyd kept crying out for his mama, they assumed it was for his mother. It turns out he may have been referencing his girlfriend. So okay. that it would explain, and it's a minor matter, but it would explain his mother himself. His mother was dead. So the question was why he was, calling out for mama. And now it makes more sense. It was because it was his girlfriend. Most likely that's what he meant. We can't know for sure, but that was the only no major evidentiary significance beyond that.
Okay, and that doesn't make it, as far as I'm concerned, doesn't make it more relevant or less tragic. That's crying out mama if it's for your girlfriend while you're in a state of distress is no less tragic and upsetting. What do you think is the biggest evidentiary revelations? I guess they're not revelations; we've known them already, but that have been now formally adduced as evidence. What do you think the biggest ones are?
There may be a different culprit for George Floyd's death, and that culprit may be the drug dealer. So it turns out that the person in the car with George Floyd was his drug dealer, according to the testimony of his girlfriend. And there's evidence it appeared that he was, that he had used drugs before he went into the store, given his behavior in the store. There was interaction between he and the drug dealer in the store. What I suspect is that it may have been the case that he wasn't buying cigarettes for himself, that the drug dealer was like, I'll give you drugs if you'll pass these you pass these counterfeit bills to buy me things that I want. And that may explain why the drug dealer's in the store, but doesn't appear to buy anything, is watching Floyd buy something, and is with him in the car. So so a lot of this may be sort of on the drug dealer, but the main potential legal culpability is if according to the girlfriend's testimony, they didn't know they were being given fentanyl frequently by this guy. That they didn't know what it was, but that it caused her to have major problems, him to have major problems. He had not only had he nearly overdosed a year before after suddenly ingesting drugs at a prior police arrest, but he had also nearly overdosed 2 months before, such that he spent 5 days in the hospital. And she later learned that it was heroin or something like that was in his system. And fentanyl is something people use that are trying to get off of heroin. Though they usually don't intend to use fentanyl. They use some opioid that is just laced with a heavy level of fentanyl. And the question is, did the drug dealer? So that will also explain why Floyd is so nervous when the cops come. He has his drug dealer in the car with him, who likely has drugs on him. The drug dealer may have been the one in part who wanted him to ingest those drugs suddenly, so that there was no, because the drug dealer could get in much bigger trouble because it would lead to much bigger problems for him.
And actually, to stop you there, so from what I understand, the drug dealer's name, I'm going to forget it if you remember it, but he's the one now, Morris, I think, he's the one who has now announced that he would take the fifth if he were called to testify, so they made a motion to quash his subpoena.
Correct. He lawyered up, pretty smart. He had been talking about, all this had been hidden by the press and by the prosecutors. They had not disclosed this to anybody. Instead, the news was that this guy was going to be George Floyd's voice. He was going to be a very effective witness at trial. Nothing about him being the drug dealer. And it appears they knew all along. Not only that, the history of, if people don't know about fentanyl abuse, many of the people who take fentanyl don't realize that either that fentanyl is even in it or the level of fentanyl that's in it. And that a lot of those are considered accidental overdoses because they don't realize what they're receiving. And so the first question would be, did the drug dealer sort of create this whole problem by having Floyd pass the counterfeit note and the rest? And the second, and by then encouraging him, incentivizing him to ingest the drug suddenly so that it's not found on either one of them. But whether or not he gave him something that Floyd thought was different than what he was ingesting. And frankly, that probably fits the definition of reckless homicide. And the police, rather than investigate that, the prosecutors, rather than pursue it, if we had an honest investigative press, rather than inquire about it, kept it all a secret until it came out at trial when the girlfriend was testifying. And so I've seen comments by Rosanna Arquette and a lot of people. This is a classic version of motivated reasoning. If you want to see how powerful it is and understand why jurors make up their mind early and bend the evidence to fit their preordained theory, just look at Twitter or social media, anyone else. No matter what happens or the mainstream press, no matter what happens, they only spin the story to be hurtful to Chauvin and support their narrative. They bury anything that counteracts their narrative. Well, I was talking to my brother-in-law who didn't know about any of this and was shocked by the details of it. And he's someone who relatively follows the story because he's been the victim of racial targeting by police in the past himself. So he can relate to that part of the George Floyd story as presented by the press, not knowing that there's this whole other story, not only about whether or not the sudden ingestion of drugs caused the death, but maybe the drug dealer encouraged him to do it, helped create the whole setting for it to happen, and gave him something he didn't know what it was. A lot of the fentanyl overdoses are accidental overdoses where they don't know it's laced with as much fentanyl as it is. And given the girlfriend's testimony, she provided further evidence for that this drug dealer was constantly giving them something that was different than what they thought they were getting. And so but it's astounding. But that narrative doesn't fit anybody's narrative from the press or the police or the prosecutor's position.
You have Chelsea Handler on Twitter saying, why do we even need a trial? We have video. I was like, now this is an interesting thing because, and it goes back to the video I did the other day where, I know what I thought at the beginning, like when all we knew was what the media was reporting. I know what I thought. And I played the game at the time. I said, well, what would I have to learn in terms of additional information to change what I think right now? And I said, I don't care what George Floyd said to Chauvin beforehand. I don't care what I don't care what occurred beforehand. What I saw in that video, what could change my mind in terms of the consequences following from what I saw in that video. And, people are going to call me biased or just, stubborn. I'm clinging to my initial reaction. I have now, if I'm a jury member and I learn what I know now compared to what I thought I knew then or my initial reaction, my mind is somewhat more open now to what is arguably the overcharges. They're charging him with something now given the information, I can see it becoming increasingly difficult to prove beyond a reasonable doubt. whether or not I think, what other lesser crimes Chauvin might be guilty of. I don't know what lesser, like excessive force, assault, whatever, what they're charging him with now. Given what I knew then, I said a few things were going to change my mind back then. Knowing that he might very well, knowing all this, you'd have to have a closed mind to not say there might be, you may still think Chauvin is guilty of everything, but you'd have to have a closed mind to say this is not going to raise a reasonable doubt. Now, Nick Ricade on his channel saying, it doesn't matter if he were about to pass away in 10 minutes. If what Chauvin did caused him to pass away in 5 minutes, you've nonetheless robbed someone of 5 minutes of their otherwise short lifespan that's remaining. So, I mean, what's going to be the argument to counter that?
Well, the legal factor is substantial factor. So that's it. Was it a substantial factor in his death? And that's sort of a separate analysis from what his intent level was and what the elements of the crime were. So they could have charged him with just assault, and they would have gotten almost guaranteed conviction. They didn't, because they want to force the jury to convict him of murder. They could have accepted a plea deal where he would have done about 10 to 20 years in state prison. They didn't, because they want to convict him of counts that simply don't fit. It is I refer to it, I was on the gaggle with George Samueli, which people can watch. And I said, this is really a Soviet-style show trial, because so much of the trial is not about the facts or the law. It's a show for the media and for public consumption. And part of that is the overcharging. And it's not just me who believes this is overcharging. Dershowitz has said the top two counts simply don't fit, period. And he's been a strong Chauvin critic. Mark Garagos, who I've been critical of otherwise, comes from a very, very different perspective than me. He's referred to it as a show trial. Norm Pattis, who I've had some disagreements with in the past, he's from the left. He referred to it as a show trial. So you're seeing more anybody experienced in criminal defense and that's willing to be honest. Now, many are not. Garagos reported that the press can't not even find defense lawyers to give a defense perspective in the court of public opinion on this case.
Yeah, I mean, we saw Sarah Sidner, her reporting, where it's like you're going in on Team Floyd and reporting only on beneficial stuff to prosecution and utterly ignoring the good points the defense raises, which, like I said in my video, is going to create an expectation where people might face a result. They're going to say, well, how did this happen? I didn't hear the CNN reporting on any of the other stuff. And it does a disservice to everybody. But okay, now getting back to something that Nate and I have been talking about, the felony murder charge. So apparently the felony murder in Minneapolis is very different in that in order to get to felony murder, all you have to do is prove the underlying felony, and it's strict liability in terms of resulting in the death, and in which case you get felony murder. So even if you were able to get easy conviction on assault would be a felony, I imagine, leading to death. Why would you not necessarily get to felony murder in any event?
This is why. Felony murder is supposed to be a completely separate felony from the murder. By that definition that people are pushing for felony murder, every single murder is by definition felony murder. Name me a single murder you can commit without also committing an assault.
No, I think you mean every manslaughter would necessarily be felony murder.
No, felony murder is felony murder. What I mean is felony murder is supposed to be where you're doing a separate felony that's so inherently dangerous, usually to a wide group of people, that that if a death happens, you're responsible for felony murder. There's been a lot of criticism of felony murder over time, because if people see how it's applied, sometimes it's absurd in its application. But
can I stop that aside? Nate gave us example during a stream with Eric Hunley. Check him out, by the way, on Locals and on YouTube, where he said sometimes let's just say a bank robbery, a cop kills one of the assailants, one of the perpetrators. The other perp can get convicted of felony murder because his co-perpetrator was killed by the cop. Is that an absurd example?
Oh, yes, and that's happened. And the idea is, if you commit a certain inherently dangerous crime that has a real high risk of death attached to it, then that's where it's a separate kind of crime. Then if a death happens, you're going to be considered felony murder culpable. That has usually been bank robberies, kidnappings, terror type events, things like that. it is almost net. Well, as Dershowitz said, it makes no sense. If every single assault can be charged as felony murder when a death results from the assault, then every single murder can be charged as felony murder. There's no murder you can't commit without committing also an assault. So that makes zero sense. It's not supposed to be a lesser included. Right? That's not what's supposed to. It's supposed to be a totally separate crime with its own separate elements. And to give you an example, in Minnesota, to make this clear, they specifically said drive-by shootings cannot count as felony murder, and that sexual assault that leads to death cannot count as felony murder. So they were making the point, we don't want someone trying to commit the murder to be charged with felony murder. You either get charged with intentional murder, reckless murder, or manslaughter, but not felony murder unless it's a separately inherently dangerous felony that we want to punish you when death is the consequence of you committing that inherently dangerous felony that wasn't intended to kill someone. It was intended to do something else. So that's why this is what Dershowitz said. Almost every self-respecting criminal defense lawyer has admitted this. Almost no one will go on and say this makes sense for felony murder. Most of them keep their mouths shut.
Well, I pulled up Nate's message here, which he knows how to spell. I think he's just angry and putting it in caps. He's not angry either. He's typing fast. Tell Barnes there is no murder doctrine in Minnesota. I'm not saying Minneapolis. In Minnesota, the complaint says the underlying crime is assault.
Makes no sense, because by that definition, and can Nate tell me a single murder you could charge that wouldn't also be felony murder? Name one. How could you commit a single murder without also committing assault? You can't. There's no way to do it. I've even tried to think it through. I've been asking other lawyers, like, name one. Nobody can name one. Well, then what's the point? Why have a separate felony murder charge if every single homicide can be charged as felony murder? Well, why exempt sexual assault that can lead to murder? Why exempt drive-by shootings that can lead to murder from the felony murder statute? That's why it makes zero sense.
Now, but is this argument, or I don't know if it would be the question of the constitutionality of this provision of law, is this at issue now, or at any point will it be during this trial?
Oh, yeah. I mean, they moved to dismiss on these grounds, and the judge's excuse for it was not a strong argument at all. He got some basic stuff confused. And so far, no one has pointed to me a single example where somebody killed somebody and they were charged with felony murder, where the only underlying felony was the assault that led to their murder. I mean, that I've seen zero examples so far in Minnesota or anywhere else.
Yeah, and incidentally, sorry, take that out. One of the examples that a lot of people were referring to, apparently I think it was, I don't want to make a mistake on the name of the case, but the underlying felony was actually burglary and not the assault itself. So
right, it's those kind of things. You do something that inherently creates an undue risk of death. You're going to be responsible, no matter why the death comes about. You're going to be responsible if a death happens during the commission of that crime. So that's the whole. If you understand, this is why Dershowitz was like, "This is absurd. The felony murder doesn't fit." And again, he's a harsh Chauvin critic. So the other people that looked at this said this doesn't make sense. So so I think legally it doesn't fit at all. They're going to be given questionable instructions, so it's going to be a question on appeal. But again, this is what Garagos was pointing out. He was saying all these people that are cheering this are making some of the most dangerous precedents they've ever met. And it's coming from a lot of the lefty criminal defense crowd. He's like, think long and hard before you get excited about this method of evidentiary presentation. Think long and hard before you want these kind of laws elastically expanded like this, because they're coming for you next. You're going to be the number one victim of it. People, the constituencies and communities that you back on the criminal justice left, and that they're too blinded by the politics of it to do a Dershowitz style analysis. So the same problem with the third degree murder. The third degree is supposed to be so gross. My question to people is, tell me now, what's the difference between third degree murder and second degree manslaughter in Minnesota? Because as to this one, there's none. There's no difference in the definition of the elements now.
Well, I mean, depraved mind versus reckless act. I don't know how you could enact this.
Here's the thing: when you dig into depraved mind, they define it as the exact same way they define a reckless act. It's defined exactly the same now in Minnesota.
It's very interesting, because I mean, I'm reading through the charges. I don't understand how you can get to felony murder when
poisoning is an assault. Poisoning is absolutely an assault. People don't understand how broad assault is. It's any invasion of a person's body by some physical means. It doesn't have to be direct. So it doesn't have to be punching them in the face or hitting them. That's what I'm saying. Find a way you can murder someone without assaulting them. Like, let's say you attempted poisoning, you didn't kill them, you didn't even attempt to kill them. The poison was something to make them sick. You can be charged with assault. It happens all the time.
So
actually, that's why people have, it'll be a good, maybe someone can find me. Maybe they can trip up the Barnes. If they find it, God bless you. I'll pin your tweet on Locals. VivaBarnesLaw.locals.com.
So someone asks here, how can they charge felony murder based on assault when he isn't even when he's in charge or convicted of assault?
Because they don't want the jury to have the option of assault. But it's a problem because it's a lesser included. Felony murder is not supposed to have a lesser included. So that defeats the point of the purpose.
But okay, is lesser and included in manslaughter assault as well?
No. Manslaughter is you just engage in reckless conduct that causes someone's death. That doesn't require an assault.
So there is
but
no.
It almost always probably would. I don't know many circumstances where it wouldn't, but it doesn't. But even there, that's not a problem. Felony murder is so distinct. It's supposed to be a unique kind of felony that's separate and distinguishable from the murder. Otherwise, like I said, every murder is felony murder. You can charge every murder now with felony murder in Minnesota if this precedent holds. Felony murder has a 40-year prison sentence. The point is we're supposed to have these different degrees of culpability and different degrees of sentencing in proportion to that different degree of culpability. Not in Minnesota anymore.
Well, I'm bringing this up because Ed Snowden, people are going to rid me as though they've somehow found a gotcha that I'm biased and they can write me off as biased. I'm disclosing my opinion on this, not to try to prove a point, but to let you know that this is my framework so you can assess what I'm saying. I'm giving as much of an analysis of everything as I would otherwise, regardless of how I feel about it. But I'm telling you that, Ed, I said it from the beginning. When I see someone kneeling on an unresponsive person's back for 3 to 4 minutes after they've stopped being responsive while they're handcuffed, yeah, I think something's wrong there. Now, admittedly, at the beginning, I thought something totally different in terms of, causality and absence of other potentially contributing factors that could raise a reasonable doubt in a jury. Do I still think that there's something problematic and dare I say, potentially lesser crime, but criminal about a police officer maintaining some form of position on an individual who is handcuffed and unresponsive for over 3 or 4 minutes? Yeah, I think that's a problem. I don't know what the statutes are. I don't know if there's a failure to administer aid, if there's assault. I don't know what that could qualify as, but regardless of whether or not Chauvin was the determinate cause of death or where there's reasonable doubt as to whether or not he was, I consider that behavior for a police officer to maintain that position on a handcuffed individual who is on his belly and unresponsive for 3 to 4 minutes. I consider that problematic. You can call me biased. It's not going to change my analysis on the rest, but I think it's good for you to know my position at the very least on that. So as a question of transparency, not as a question of trying to tell you that he's guilty of something. I'm just telling you, that's what I think. I saw the video and now I know these additional facts and can see how this can raise a reasonable doubt on the charges that he's charged with, which is part and parcel of the problem as far as, most people are concerned.
And I think and that's always going to be the biggest hurdle for the defense because it's far from clear that is consistent with his training, though the training doesn't appear to me to be crystal clear either. Now, in terms of the evidentiary presentation, this has been the prosecution. I got the book Reptile behind me. It's about the reptile brains, written by 2 prominent plaintiffs' lawyers. And the reason I'm recommending it is emotion sells. Scott Adams makes this point repeatedly. The myth of lawyers is that we're taught to think like a lawyer. And what does that mean? It means to think about the law, think about the facts, be able to change your motivation to improve your reasoning by changing which side of the aisle you have to be on in a particular mock trial or moot court or the actual practice of law. The reason why you have to be taught to think like a lawyer is because most human beings don't. Most human beings are not driven by mathematical, deductive, and inductive reasoning. We all like to think we are. But Eric Hunley on his Unstructured podcast, which you can find at unstructured.locals.com, they had Chase Hughes. I was almost blanked on his last name, but Chase Hughes on the back of he described that almost all of our decisions, 90% of our decisions, are made by the sort of back of our brain that's not really conscious. That's what they're describing in the reptile brain. That's based on a wide range of survivalist techniques, and then our neocortex rationalizes that decision. But that's why I say motivation is the master of reason. Reason ain't the master of motivation. So if you want to improve your reasoning, change your motivation in a circumstance or situation. But normal people don't. And the prosecution went with a emotional, visual approach. That's a second lesson people should know in general in life. Be visual. To give you an example, Robert Grueller, also on Locals, watchingthewatchers.locals.com. He's been doing a lot of good daily analysis and updates of the trial, so people can find that each day if you want a sort of a concise digest summary that includes clips from the actual trial and his analysis of it. But he gave an example of of how to be visual. He said what the defense, he said the prosecution wants you to see the case. Actually, I'll steal the little thing he sent me as a gift, watching the Watchers, one of these. It's like the prosecution wants you to look at only one little piece. And he visualized it like this. And the defense wants you to broaden your scope and see the context. Now, that's a good visual reference. Unfortunately, the defense lawyer didn't give one. To give an example, in the Snipes case, that was a 2-week trial. Now, it's a federal trial, so those go longer. But it's still half the length of this trial in terms of duration. And we gave 3-hour opening statements each. The defense gave a 20-minute opening statement. Massive mistake. And the reason why, with almost no visuals at all, while the prosecution, they were also short. I would have had that jury crying after I gave the prosecution. They would have been tying the knot, ready to go, asking where the platform was. He did decent, but he used visual references. For example, they used a chart. It's this part, most of the prosecution we previewed before it even gave the opening statement. They gave almost exactly what we talked about. They just could have used more emotionally impactful language, in my view, but that's another story. But they did a chart, and here's where they genius. They did a timeline. Always do a timeline. It's always good. They did a timeline where they managed to have one photo on it 7 different times in the timeline. Take a wild guess what that photo was. It's the photo of Chauvin on the neck of Floyd. They managed, it was kind of subtle, but not so subtle at the same time. But so they're locking into people's brains every piece of time with that photo over and over and over and over. They use good language. They said, the police badge is a small badge, but with it comes big power and big responsibility with that power. They had some, good phraseology throughout that if someone's in your custody, they're in your care. Good little lines like that. And so it was pretty well done. Not as well done as it could have been, but above average for prosecutors by far. Then the defense came up and did a 20-minute linear police report style defense. And there was some good utility to it from a framing perspective. He said, let's look at the 4 pieces of evidence, the 4 places where you're going to see evidence, the store, the Mercedes, the squad car, the hospital. It was smart. It was very subtle, but smart to throw in Mercedes. That's what George Floyd was in. And because that's creating a different impression of Floyd, right? It's not creating the impression of Floyd in a poor person's car or something like that. It's Floyd in a Mercedes. The nice, subtle thing he did. But otherwise, it was too lit. But it's the way we're taught as lawyers. Think rationally. Think in terms of evidence. Think in terms of deductive, inductive reasoning. Think in terms of law. That's not what sells with juries historically. What sells with juries is emotion, 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 and their survival instinct. And so that's what the prosecution. And then, even Garagos and other people were saying it was outrageous how emotionally pitched this trial was. Some different defense lawyers are saying this is unsettling. This is a bad precedent to set. You're not supposed to put up witness after witness after. They had 8 witnesses, I think, cry on the stand. They had fire workers cry on the stand, sergeants. They had young kids, older people, middle-aged people, men, women, all just cry. How these people feel is not really that relevant. It's potentially relevant to sentencing, and that has to be determined by a jury in Minnesota. But that's really abusing it, and it seems like just getting a read on it, which is difficult. But it looked like the judge was uncomfortable with the scope of this. But from a trial presentation perspective, it's very, very smart. They just saturated that jury in emotion from every different life perspective that could possibly be presented. From the most sympathetic, for the most part, there were some people that weren't. The MMA fighter wasn't that sympathetic because it was obvious how hostile he was, and the fire worker lady was not that sympathetic because she contradicted her own testimony about what she would do if she was in Chauvin's shoes as a fire worker. But the others were little girls crying on the stand, old nice gentlemen who say, "Oh, I'm just nosy," came across friendly cat. I'm just your nosy neighbor, likes to look at stuff, crying on the stand. That's what the case has been. It's a Soviet-style show trial. And it's becoming increasingly a disgrace if you care about American criminal justice. And I think the defense, now, to his credit, defense lawyers excellent cross-examiner.
I was
He takes a
actually,
scalpel.
I was going to say that because people have to appreciate how hard it is for the defense attorney who has to cross-examine the girlfriend of the deceased victim in this. And you have to be aggressive, you have to be mean, but you can't look like you're being aggressive or mean as if you are giving, the girlfriend of the deceased a hard time. And so he's walking a thin line when he does it, or a fine line when he does it. He's doing it pretty well. I mean, he got her to admit certain things. I think the pet name comment came out badly, but I think he did well enough with it to bring out that element and to get into the drug issues and to bring up the past history of OD, which they were allowed to administer as evidence. He's doing good. He looks a little good. He looks like an uncomfortable sort of goofy teenager, which allows him to do his job better, because if he looks like an aggressive bully, it won't go well.
He's very experienced at cross-examination. That is quite evident, and very skilled at it. There's a lot of people who are very clumsy at it. So where I'm critical of the opening statement, but though, again, 90% of criminal defense lawyers would have done that, and he may know things I don't know. He may have focus grouped the case. He may have jury trialed the case. He may know that he's doing a different emotional pitch, saying, look, appealing to the jury's ego. You don't want to be inflamed by emotion. You want to make a decision based on calculated reasoning. And so let's lower the temperature and think just in terms of empirical evidence. And it's really a different kind of emotional pitch. That may be what he's trying. It's just, I thought it was a huge gamble. Also, lawyers have this illusion that jurors are just invested in the case, and they're not going to make a decision, by golly, until after closing arguments are made. So they'll save a lot for closing arguments. They'll hide a lot of their key evidentiary reveals for cross-examination that they think might be undermined if they tell everybody in advance where they're going. That it just doesn't work that way. Just follow the people on Twitter who think he's guilty. Now, they've been utterly unaffected by anything that's happened.
I'm sure they're unaware. I'm just sure they're outright unaware. Now, the one thing, actually, I brought it up before, but let me take these three. There was a super chat from Nate that I think we have to get to before two specific questions. Okay, this is not it. George Floyd was okay. No, this is here. It is right here. Come on. The felony murder doctrine is properly applied when the underlying felony is aggravated assault. State v. Carson. Yada yada yada. Boom. Okay, we'll have to look into it. Screenshotted, Nate. We have to trust but verify here. But here's the question. A lot of people are talking about...
That means the felony murder statute makes no sense in Minnesota. That's what that means. That the felony murder statute makes no sense at all in Minnesota, because that means that they intended for assault to lead to felony murder, but not drive-by shooting to lead to felony murder, when they explicitly said that. Not sexual assault to lead to felony murder. Does that make any sense? It's like, okay, if you just beat up a person and it leads to their death, then you can get 40 years in prison. But if you also rape them, then you can't. Does that make sense to anyone? Does that really make sense? So the logic of that, usually with those kind of cases, involve a case where the person's not trying to kill them, not trying to murder them, like it's a bar fight with 5 or 6 people and somebody ends up dead, something like that. That's usually, it's supposed to be a separate felony that's not just an underlying lesser included of felony murder. Otherwise, it just doesn't, like I said, doesn't make sense. Every murder could be charged as felony murder. I mean, every assault could be charged as felony murder. And then why even have other murder statutes? You're just wasting your time. Just charge all of them as felony murder.
I think that might be one of the criticisms. I just wonder if that's going to be the ultimate reality of Minnesota law. Question people are bringing up a lot, and it's a distinction that I think needs to be made. A lot of people are saying what Chauvin did was specifically permitted under MPD training manuals, to immobilize someone who's resisting, knee or foot on the back or the neck, wherever. And so what he did was okay. The distinction, from what I understand, is that that's okay up until the time where they are restrained in handcuffs. And at that point, the foot is supposed to come off. Some other people have been pointing out, no, there's a maximal restraint where you're allowed to keep it even after. And from what I understand, that's not exactly the case. Nate's in the chat and maybe can clarify this, but from what I understand, that's not the case if the individual has not been fully restrained, including the feet. So one way or the other, it was against MPD training manual for Chauvin to maintain that position after Floyd was restrained, and certainly after he was non-responsive. Now, the only question is then, what could, if there are going to be proper charges, what would those be versus the charges that have been brought? That's a hypothetical that we may never know. Robert, I guess, okay, actually one question here. They could never now recharge him with a lesser crime because it would be too late?
I mean, well, they can, I don't know what Minnesota's procedures are. Usually you can always request a lesser included. It may not be in Chauvin's interest to do so. But it depends on the jurisdiction. Usually you can always request that at the time of the close of evidence. But I don't know if Minnesota's protocols, procedures allow that or when they allow that to occur. There's a lot of dispute about what the training actually provided for and what the training actually was. One problem was you combine a policeman with a politician, and you're going to have the biggest, most successful liars in the world. And I know some of my cop friends and cop folks won't necessarily. Well, some of them actually totally appreciate that, because if you watch like a WWE film or any of those films, the cop on the beat is the hero. The people higher up are always the corrupt politicians, and that's because that's who they are. So they had one of those. They got a sergeant on the stand, but the sergeant wasn't really willing to be that critical of what took place. The lieutenant, he was eager. He was ready for TV, and he was ready to lie for the world to be promoted in prominence. And because this is a guy who's not a beat cop, this is a guy who sees an opportunity to rise up the food chain, to get promoted, to get hyped, to get celebrated. And there's a lot of those at the high-ranking positions in police departments. Unfortunately for the prosecution, there were two problems. One, he was so eager to lie that they had to interrupt him before he told too many dumb lies. So like the very first time they're asking him a question, he's like, boom, he's ready to turn to the jury and give it to him. Oh yeah, what he did was, I've never seen anything like that. That's never been approved. That's never been okay. That's clearly excessive. You can kill someone when you do that. But the first problem was it was too overbroad, because the jury's going to see evidence that contradicts what he was trying to say. What the prosecution was trying to say was if this, and then if this, and if this, and if this, then that. He jumped the gun. If this, boom, he was off and running. And they had to try to bring him back, but they only partially did. The second problem is defense lawyers were saying, even on CBS this morning and other places, that there could be a motion for mistrial because he was not qualified as an expert witness. So what they did is they elicited expert witness testimony from someone who had not been qualified as an expert witness. And it was highly inflammatory, prejudicial testimony. It was something he was not qualified to give, hadn't been qualified in advance to give. Maybe theoretically he could be, but he's here the defense lawyer was sophisticated. He left at the right point, and the prosecution has done very well and stylistically and technically in their direct examination. They leave at the right point. They get a high point, they sit down. They don't drag it out. Defense lawyer's been doing the same thing. He's clinical in his defense. And he finished with basically, aren't you the tape guy? You're the guy who shows up and makes sure the tape is lined up right. And now you're an expert on use of force when you've been the tape guy for about 20 years, making the point this guy's nowhere near in a position to say the things he said. He also, remember, Minneapolis police originally lied to everybody and said they never approve of a neck restraint. No. They thought they apparently were unaware of way back archive. Like I say, everybody, never in writing, always in cash. But apparently these dimwits didn't understand that. And so ordinary sleuths in the internet found, hold on a second, that isn't what your training used to show. And of course, the jury will see a photo that was in the training by Minneapolis police recently that has a man already handcuffed and the guy still with his knee on the neck after he's handcuffed. Now, the question is the interpretation of some of that guidance, because it next says you should turn him over. But if you look at what position the photo chose with him turned over, he's no longer handcuffed. So it's not clear that second position relates to the first, given the visual imagery that's being taught. It seems to be something separate, something different. If you have this situation, you do this. If you have this situation, you do that. The clear defense line that the defense lawyer is pursuing is that Chauvin, because of the crowd, wanted to maintain control and didn't tie his feet together and then maybe flip him over, even though one officer recommended that because he thought it would even be worse for the crowd. He's like, I'll just stay here. Ambulance is on the way. Ambulance will show up, and so forth. So it appears, I don't think the evidence will show ultimately that Chauvin thought he was causing lethal harm or intended to. That doesn't mean they won't convict him anyway. But I do think there's an intent problem with the evidence presented so far. What they needed to say was every cop knew this is so reckless that you intended to kill him. And what the ultimate evidence, and that's what they sort of elicited from that lieutenant. But the actual evidence from what I've seen, and the reason why this gets confusing is there's different police training in different parts of the country. So there's police training in some parts in the world. Some places don't use the neck restraint. Some people do. Some states only use it for this purpose rather than that purpose. But I will say this. Here's why I knew the lieutenant was lying. He suggested that as soon as you handcuffed someone, you no longer needed to put any other restraint on them, even put them in the prone position. Well, just Google, find the number of deaths that have been found from a cop putting their knee on the neck. In Minneapolis, for example, there'd been over 200 uses of it. In the 5 years prior to this, no deaths. It wasn't unusual for them to go unconscious. That's where the non-responsive part wouldn't be a problem necessarily. 1 out of 5 times they would go unconscious, but that was seen as okay because you think they're on drugs, they're losing it, they're acting irrationally. If they just go unconscious, better off for them. And they even had a training mechanism to actually called it the unconscious neck restraint method in Minneapolis. But by comparison, Google, this is why I knew the lieutenant was lying. Google handcuffed person shoots police officer. Handcuffed person escapes. Handcuffed person kills somebody. It happens with disturbing regularity. You'll find lots of examples of it. So when that lieutenant said, oh no, as soon as they're handcuffed, you have nothing to fear anymore, he was lying. And I would have been a little more aggressive if I was a defense lawyer than that individual was. I think he was surprised. The prosecutor decided to sneak this in. And they're taking a lot of risk with this judge because the judge seemed irritated as well by the way he was cutting off the lieutenant. But they created a mistrial risk by what they did. Well,
the amazing thing is people who are not aware that these are practices employed, everywhere, that these are actual formal police policies as to or how to deal with individuals when detaining them. It'll be shocking to some. Just going to read a few chats that I want to get to. This is my last $5, so please read the chat. Could Chauvin have chosen the judge to decide the case instead of a jury? Answer is yes. He could pick a trial by jury or judge.
Yeah, but the prosecution can refuse that.
And then what are
both sides are entitled to a jury trial. So you'd have to have both sides waive their right to a jury trial to get a jury trial in most jurisdictions.
Very interesting. Now, someone else had asked, and this was a question I had when I heard the potential drug dealer was taking the fifth. Just dropped my phone. Can the defense not call him anyhow, even if all he's going to do is take the fifth to show what this individual is and what he has to hide in order to raise that element of doubt for the prosecution? Can they nonetheless call him, even if all he's going to do is plead the fifth?
Well, there was a high-profile example of that in a famous high-profile case where the lead police officer took the Fifth Amendment. The police officer who magically discovered all the evidence in the case, or almost all the evidence in the case, took the fifth. That was Mr. Mark Furman in the O.J. Simpson case. And they put him up for the purposes of cross-examining him and him just taking the fifth. Depends on the court. Some courts won't allow it. Some courts will, because the questions are not evidence. So and whether or not you can make an evidentiary inference from a Fifth Amendment assertion depends on the court and the circumstances. So that will be an open question as to whether they go that route or path. It was interesting. Once he developed it, I realized that he might have been planning on that all along. That he may be playing, like my view again goes to Thomas Mesereau. The jury wants a white hat and a black hat. Something bad happened. They want a white hat and a black hat. And I think he may be thinking, don't put the black hat on Floyd for suddenly ingesting a lot of drugs. Put the black hat on the drug dealer who didn't tell him what he was ingesting was so lethal. That would be a smart move. That'd be a surprise move. I didn't see it coming, didn't know anything about it, because that's an easy one for the jury to do. It's an easy one for the jury to say, I don't want to blame George Floyd because he died and I feel bad for him. And they played the violin on that. I mean, they played it with not only all the emotion, but putting up the girlfriend and how did you meet him? And he came over and he wanted to pray with me and so on and so forth. And, we had all this pain and that's the only reason why we took drugs and we were too poor to get drugs. It was very, very well done. Very, very well done. And I don't, by the way, I don't disbelieve any of her story. This would mean that they, in a civil case, try getting away with that. Most of the time, judges will not allow you to, in their view, play to the emotion of the jury overtly like that. I haven't seen and Grago said the same thing. Said he hadn't seen a case with that much just emotion after emotion after emotion. He's like, this is a dangerous pattern. He goes, people should think about it when their friend family member or community member is a criminal defendant next, do you want all of that crying on the stand to take place? Because that usually leads to a lynching verdict, not the one not based on reason, not based on evidence. So, but it was well done by the prosecution. But that would be a brilliant way to shift the black hat. Tom Mesereau was a genius of it. He was the guy who defended and got Michael Jackson acquitted. So if that's where he's going, then that will be impressive. Other than his opening statement, he's really been a very good defense lawyer. Not necessarily the greatest on the motion practice, but that's not uncommon. Your good evidence lawyers are rarely your good appeal lawyers. There's only a few of us who might fit that category.
And I guess, so what do we expect for the next week? Do we know who they're calling, what the order is?
Now it's going to be expert time. So emotion, visual. Now it's going to be the prosecution overloading the jury. This was why they took an unnecessary risk with the lieutenant. Just put up your use of force expert. You don't need to sneak it in with the lieutenant right before the jury goes home for the first weekend. I get it's tempting, but you created a real high risk of that being a mistrial. And with this judge, I wouldn't have taken that gamble with the prosecution because they're going to have a bunch of witnesses get up. Because the training was kind of vague, in my view, in Minnesota, and because people can research this. The reason why police officers do this, because I researched this years ago, I don't like it. I've been a critic of the spit mask. I've been a critic of even though they let those cops walk in Rochester related to it, I've been a critic of the neck hold. I understand why they do it. I just don't like a lot of these aggressively physical methods of restraint. I understand from the cop's perspective why it's often less risky than something else happening. But I just think it has too much risk to it. But I can say when I researched it, the evidence doesn't really support my assumption of risk. That the evidence is that the way in which the hold is done, there's very, very few incidents of it ever leading to death or severe bodily harm.
I brought up a comment from, I think it was Lone Wolf Ranger or something, says there haven't been 200 to 300 cases of someone doing it for 8 to 9 minutes. And
that's a fair point. Though there was one in Minnesota, or it was at least the 8th Circuit, where they had, he was under for 15 minutes and he died. And the cop and they said that could not, as a matter of law, be unreasonable force. And do you think that lieutenant who testified last week didn't know that? He knew he was lying. He was just happy. You could tell how eager he was. He's like, I'm getting promoted now, baby.
And that's the thing that, we discussed what precedential value other precedent will have, but people don't even know. There was another case recently it was in the instruction manual, 15 minutes. Now, apparently the distinction in that case, for everyone to know, it was 15 minutes to get the individual restrained. So it was not that the individual was restrained for however long and then
so he was restrained for, I think, at least a substantial time of that. His arms were at least restrained.
That's the thing, and I think it was like a full restraint because it was maximum restraint. There's a mild distinction that it was not as though the individual was unresponsive for 5 of the 15 minutes. Maybe for some a distinction without a difference, but most people don't know. 15 minutes in the same position led to death and acquittal, and the media is not going to report on that at all, even to prep people for the potential, because they want maximum shock and outrage based on maximum bias coverage, which is not going to reveal the strengths and weaknesses of both sides, because to reveal the strengths of the defense here would be traitorous to the tribalist politics that has now ingrained this case.
To the purpose of the show trial. And looking at it, and then the second problem is compounded here. So first is that if you're a police officer, the person becoming non-responsive would not be uncommon, in that 1 out of 5 people that the hold is used on would become unconscious. But there was no reporting, at least that I had seen in like almost 15 years in Minneapolis, of anyone being alleged to have died or suffered severe injury from it. The other component is the evidence here. The evidence here is no damage consistent with asphyxia. I mean, what the coroner originally said was, if you just brought this guy into me without giving me any other background, I would have concluded overdose, because he doesn't have any signs of damage here, no signs of damage here, no signs of damage to the ribs or others that would be indicative that the body compression is what caused his death. It appears that the coroner's at least adjusted theory after they had a nice little chat with him. That's why the state prosecutors for the county got kicked off the case, because they had that little chat. And I think the judge whiffed out what that was about. It was about them switching testimony. And I think it's more like the theory really is that the stress of the hold caused the death or contributed to the death, not that the neck hold restraint itself caused the death. But we'll see. That's at least how the coroner adjusted. But the whole medical profession is of the political mindset to lynch someone like Chauvin in a case like this, especially. So they have, in my view, cumulatively, they have 8 medical experts, 8 doctors that are going to testify. And they're going to have multiple use of force people. So all of next week is to bombard the jury that people in positions of authority say Chauvin guilty. People in position one after the other, after the other, after the other.
But if I'm a jury member, that looks weaker than it does look strong to me. If it's a good point, you make it once, twice. I mean, the more you have, it almost looks like it's a weak point that you want to strengthen through an appeal to authority, kind of.
Yes.
And it looks like you also.
It often works. It often works. So, I mean, a lot of courts won't allow these cumulative experts. They've decided that the way they got around it is by their different experts in different parts of medicine. It's like, okay. So the cross-examination will be big, but the jury doesn't likely know yet that the coroner's report is no physical signs of asphyxia. So the later positional asphyxia definition was based on pressure from the prosecution, and then all these more politicized doctors are willing to testify in a certain way. And so this will be the sign. How good his cross-examination will be critical for undermining the jurors' confidence in this to the degree they're open-minded. Yeah, I'm skeptical of that, given what their answers were and given the venue that was selected prior to the jury, and given that I think he got behind the 8 ball with opening statement. Because what jurors actually do is they make a decision after opening statement and they start pre-filtering evidence. They do what the Twitter types do. The ones that want Chauvin to be guilty, they ignore evidence of acquittal, highlight evidence of guilt, and they keep doing it over and over. And you can't win them over. They're gone. And we're taught as lawyers that isn't the way people. The reason why we're taught to think like a lawyer is because almost no one else does. And lawyers underappreciate this in the trial context. So that's the other reason why I'm skeptical of it. But from otherwise, if this was a truly open-minded jury, the evidence has gone much more in the defense direction than the prosecution.
That's what you have difficulty having a discussion with people who have already made up the mind, and why it's an impossible discussion to have on social media. Even Nate, who some people call the far left lawyer, say, this is not my opinion. This is just the evidence that's been presented. It's a tough thing. But we should move on because we've got a lot more to cover before this is over. I think we've done a good job summarizing for anybody who didn't watch the 3 or 4 days, 5 days. Geez, whoever didn't watch it, you've got pretty much all you need to know. And some of the details, you can argue over the details of, what the manuals say, what it means, because it's not black and white, even though it's written in black and white. This is the essence. So now you can go and you'll know more than the reporting you're getting from Sarah Sidner coming out of court, despite having prayed for her. Do we go to what do you want to do? You want to do the Satan shoes quickly?
Sure, go ahead.
Let's do the Satan shoes because people have been asking the same question. I think I know the answer, but I don't want to. I defer to you at the very least for the U.S. side of this. Satan shoes, everybody knows. Lil Nas X has a company that he's affiliated with or associated with, MSCHF. They bought 666 Nike Air Max 97s, materially modified them by putting red ink in the insole with a drop of human blood, satanic theme to the shoes. They called them the Satan shoes, 666 being sold at $1,018 each, because that's a verse from the Bible that says Satan fell from the sky. Nike sued. They took, they sued for, they went with a restraining order, but it didn't look like a temporary restraining order from my reading of it. It looked like a standard trademark infringement dilution lawsuit. I said it was a slam dunk of a lawsuit because that's my belief, not my predetermined belief, because I was actually more on the fence until I read the lawsuit and saw the product. They got a temporary restraining order that I was not actually convinced they had asked for in their pleadings, and I don't know how that happened, and you'll clarify that. And I suspect the lawsuit's going to settle because I don't think there's anything to litigate over at this point. The biggest question people have, one was, why is this different than with the Jesus shoes that incident occurred a year or two ago? There were only 24 of those shoes made and sold. Why is it different? And why is this different than someone buying a Ford, souping it up and reselling it type thing? So I think I know the answer in law, but I mean, field that one for me and inform the audience why it's different, what the fundamental difference is between aftermarket tweaking versus trademark infringement and trademark dilution.
It's really the degree to which you're leveraging the trademark for the sale and the pitch and the promotion of the sale. So how much are you profiting from use of the trademark, of somebody else's trademark? So you soup up a Ford, you're selling, what you're really selling is the souped up aspect of the vehicle. You're not selling the brand Ford so much. Now that still wouldn't necessarily stop Ford from suing, and they might be able to still prevail. But what the court, in almost all the intellectual property context, what they're really looking at is, are you profiting off of someone else's investment in their brand? And if you're profiting off of someone else's investment in the brand, that's what you have to kick back to them. Now I think the reason why this got the attention of Nike and the courts is because Jesus shoes, while maybe profiting from the brand, are not disparaging of the brand, whereas Satan shoes kind of disparage the brand. So I think that's why the court was so sensitive and Nike was so sensitive to rush to bring the case.
Well, so that was one thought I had. It's disparaging, but I could see if you're religious, you don't take any more kindly to the idea of holy water being in the insoles than you do to human blood and satanic themes. So I think if you're religious, you're offended one way or the other. My thing is, everybody's saying, what about the Jesus shoe? I don't think anybody knew that they only made 24 of those shoes. 24 right. Shoes, aftermarket. I can look at those as artisanal. I can say, yeah, I appreciate that that's an art project that is not sanctioned or approved of by Nike. When I see 666 at $1,000 a pop, I thought it was a Nike shoe. I mean, until I read the article, I said, "Yo, that's a bad choice for Nike." And it's the volume. It's it becomes a commercial enterprise. It's $1 million business. 666 shoes at $1,000 a pop, $1 million Canadian. So there's that. There's the damaging aspect in my mind, and also just so everybody knows, there was a channel of this guy who rebuilt cars. Either from scratch or from movies. Oh, he rebuilt the Fast and the Furious car, and he had that car seized on trademark violation. Yeah. So they can do it on small scale and large scale.
You need to have nothing about the trademark in your pitch of the product. So if you say, "Hey, I created a car," and you don't tell them anything about what kind of car it is, nothing else, just here's the car, here's what it does, etc., but you know nothing about the brand, then it's very hard for them to argue, "Well, you're piggybacking off of our trademark." Well, if I never talked about it, never showed it, nobody ever knew it, pretty hard to argue. But here they advertised that these were Nikes.
I mean, it looked totally official. And someone asked me, I said, they could have easily gone with a no-brand shoe. They deliberately chose not to, because half of the marketing on the one hand was Nike itself, political commentary, whatever, or piggybacking off the trademark so that they could sell them for $1,000 a pop. If they're using no name, whatever, they don't sell. Maybe they don't sell for $1,000. Maybe you could not even possibly market them as the Satan shoe with its stark contrast to Nike. So I thought it was a no-brainer from the beginning, but it explained for those who may not appreciate the idea of trademark dilution versus trademark infringement.
In either case, it's when you're using somebody else's trademark for your own profit. And if you're also disparaging the trademark in the process or creating a negative association, then that's trademark dilution. Trademark infringement is where you're just profiting off of it without damaging or disparaging it. And the key is, how much are you profiting off of someone else's investment in their brand? Though some people might say Satan shoes and Nike go together quite easily.
Well, I mean, this was the whole irony, is everyone's saying Nike's objecting to blood being in their shoes when there's blood on their shoes, given how they're made. And speaking of the blood in the shoes, I know it's one drop, it's symbolic. Is there not any potential regulatory issues with injecting any human fluid in these shoes? I think the neurotic hypochondriac, but there seems like there should be some form of regulation preventing that. Is that not a biohazard?
I have no idea.
So anyways, I mean, now you would imagine as well that the profits from apparently they've already sold the shoes. If they haven't shipped them, I suspect they've already shipped 665. Nike, they're going to pay all the profits to Nike. It's a win-win situation. Everyone's got their brand built and protected in this.
Yeah, and they may go after them a little more. I think the other reason they did this is as a deterrent. They wanted people to quit doing it. They don't believe in the crossover that the people that created the shoes want to create cross influences and whatnot. And Nike has no interest in that unless they control it.
Okay, we got this here. Hold on. I can put a flux capacitor on a junk DeLorean DeLorean won't complain. No, I don't know who owns the rights to DeLorean since they've gone bankrupt, but
well, yeah, Mr. DeLorean ended up facing a lot of criminal charges over many years. That's another story. Some of the charges were kind of bogus, but that's like a future famous cases for Viva Barnes Law.locals.com.
And incidentally, one of the ones we might have to do sooner than later, someone had brought up the chat. Do you think you must think OJ is innocent? I can tell you that Robert does think that OJ was innocent, as does Dershowitz. It might make for a good evening discussion. Okay, so yeah, I mean, there's nothing more to that. It was obvious. It was black and white. It was a marketing stunt. Had they done one shoe, people probably would have not believed it was an official Nike campaign. 666 shoes, launching it as such, people believed it, and arguably rightfully so. And I'm not trying to protect my own intelligence. I thought it was an official product until I read the article. So black and white. Now, people are asking for Gaetz. We didn't prepare for Gaetz, but we might.
Yeah. Oh yeah. No, I'm prepared for Gaetz.
Okay. So, God, okay. I know what's going on with Gaetz. I watched the Tim Pool's bit. I've been reading some articles. It's a complicated thing. It seems that Gaetz was, in fact, under investigation, to use words that are not going to get us in trouble, for improprieties based on age, that he apparently was under investigation, under bar from 2020. Simultaneously, contemporaneously, at the same time, however we want to say it, it seems that his family was being objectively extorted because there's an investigation into that, because someone got wind of the investigation, said, I can make it go away if you pay me $25 million, or you have your dad pay $25 million. And so it seems that there might be two simultaneous criminal investigations going on here. One into Gaetz for very naughty behavior, if the allegations are true. The other for someone who, a Department of Justice attorney, former, who may have been trying to exploit the situation and his purported ability to make it go away for, payments $25 million. There may be more details to it, Robert. I mean, take it away, and I'm going to have some questions.
So, my guess as to what the backstory is, this is all mostly speculative at this point, is that it feels like it has the fingerprints of a deep state hit job. And so Gaetz had a relationship with someone who was a tax collector in Florida, who came under investigation somehow by the Secret Service, which strikes me as a little odd, but apparently was using his office. According to the allegations, he's been indicted, and the indictment against him involves, he was supposed to be creating blockchain technology to make people's information more private and secure. Instead, apparently, according to the government allegations, he was diverting the money for himself to purchase cryptocurrencies. He was using his access to driver's license to create fake IDs. He apparently stalked somebody online that was a political competitor and created like fake accounts to do it, according again to the federal indictment. And then the only other allegation in there was that he had facilitated someone traveling in a fake ID for someone that was under the age of 18. It wasn't clear what age they were, for the purposes of alleged sexual activity across state lines. So we have that aspect. Then we have the other aspect.
Just stop right there. At the time, these allegations, Gaetz is, 20 years older. Gaetz is in mid-30s when this is alleged to have happened.
Oh, all this was alleged to have happened within the last couple of years.
Okay.
So so that's part one. Part two is the stories that circulate about Gaetz is he's a ladies' man, and that he, might have shared photos and other images that he had with friends and pals at parties and whatnot. So that might have created a perception that this was a point of vulnerability. Gaetz' father, I think, is worth something like $500 million. His family members were independent. The most significant thing about what's interesting is none of this comes on the radar scene until Gaetz starts becoming a very outspoken populist spokesperson on the right, who is seen as a future presidential candidate in the future. There was talk of Gaetz running in high-end political financial circles, of Gaetz running for statewide office, Secretary of Agriculture in Florida, then running for governor, then running for president. And there were a lot of people who saw him as the number one potential source of he's been one of the top critics of deep state defense, whatever you want to label it, national security establishment, the FBI, Justice Department. He sits on the Judiciary Committee, has been one of the strongest defenders of Trump, has adopted kids and things like that. And he has a Kennedy-type background. In other words, he's very telegenic. He's young. He had recently been engaged. Like I said, adopted, poor kids. And because of his independent money, meant like the Kennedys, he could do what he wanted to do. He wasn't under the same limitations that most other politicians were. So I would advise you, if you're going to go after the deep state, you better check back, make sure everything is safe, because they're going to put you under scrutiny if they can. And the aspects of that have the fingerprints of this are, first, a very unusual case. So the only allegation that's been reported against Gaetz, and it's not even clear he's a target rather than a subject, is that it was that someone who was 17, he paid for their flight and hotel, and he had an affair with that person who was 17 in a different state. The reason why, a couple of things. The federal laws are unclear on this. A lot of laws are unclear. In the United States, depends on which state you're in. Some states are 16, some states are 17, some states are 18. Across the country, across the world, it varies. Some countries are still 14, but 14, 15, 16, 17, 18. The norm is closer to 17 generally than the 18 around the world, but it depends on where you're at. So and to give an example, the Supreme Court several years ago ruled that in order for it to count as sexual abuse of a minor, the person has to be 15 or under. So those statutes wouldn't apply. In addition, Scott Adams had asked, is there a defense if you don't know their age? And people are getting confused. Statutory rape charges under state law, which involve different age limits. Under federal law, if you don't know the person is 17, you think they're 18, that is, in fact, an affirmative defense under the law. And so put it this way, it wouldn't surprise me if this person he was associated with might have set him up to let him believe he was dating someone who was 18 or older and wasn't.
I'm gonna stop. I mean, look, Robert, I'll stop you. I know people that this is where people are going to say, okay, you're infusing some opinion, and
no doubt, this is almost all speculative.
Yeah, but I was going to say, you're infusing James Ellroy experience in the assessment. Here's the thing, by the way, one of my best friend's parents are 20 years apart. It's just that I think they met more in the 25 to 45 or 35 to 55 range, and not the 15 to 35 range. And so you got to,
but let me give an example. One, this is a very weird FBI investigation. It is very weird to put Gaetz under investigation for this, if that's the case. That is highly unusual. When you've got a 17-year-old, you don't know whether an affair actually happened. The only trafficking alleging is paying for their flight. There's no allegation that this person is accusing him of anything wrong. We have a senator, Bob Martinez, who used to fly to the Dominican Republic to sleep with underage girls, and he's still in the United States Senate. So that's what I mean by this is an unusual kind of focus point to have. But that's part one. But let's say you skip that. Then you look at this Greenberg guy. He's the kind of dangerous grifter type you have to be careful of, because the way those kind of people protect themselves, and I have witnessed this representing a range of people, that they want extortionate material on the people they're connected to politically as their ultimate escape. I mean, this guy, according to the indictment, while he was under investigation, went and bribed an official so he could get bogus loans from the government for the Paycheck Protection Plan, apparently. I mean, that's the indictment. So that gives you an idea of the scale of this guy, of his criminality. But, I mean, if the allegation is that Gaetz thought this person was someone on a particular website, then that person was saying they were 18. And this person did have a means of getting false IDs, may have got this person to false ID. Put it this way, it'd be a great way to entrap someone. Let's say you knew someone's vulnerability was that, that they are a ladies' man. You find you can be, hey, I got some girlfriend. They really like you. They'd like to see you. You get them to pay for the bills. You get to the airfare. Because how did the feds know this? How did they come across this? This is, were they just going through his phone bills and airfare bills and flight bills and hotel registries on a regular basis?
Oh, no, look, it is weird. I'll tell you one thing, though. Whatever defenses Gaetz has, and innocent until proven guilty, especially for some of this, seems to be a first time.
And Gaetz, by the way, has denied all of this.
He's denied it. I just said, I saw his interview with Tucker Carlson. It was a little odd if I'm looking at it critically.
Oh, yeah.
When it was a very bizarre defense. It was bizarre for Gaetz to bring up Tucker Carlson's wife, and as if to bring him into it, say, this. I always get suspicious when I see that, whether or not it's an individual who, this is, there's something to be said about getting married young and being loyal. There's something to be said about that, avoiding problems. Of course, it doesn't prevent anybody from just outright fabricating stuff, but it avoids trouble.
The nature of the people who seek politics, they're more often than not, they're going to have skeletons in their closet. When people wonder why don't people challenge corruption in positions of power, it's because you get personally threatened, personally investigated. And unless you have a perfect record, or you're Edwin Edwards, who said, the only way they're going to throw me out is if I get caught in bed with a live boy or a dead girl. Otherwise, I'm okay. I mean, unless you're Edwin Edwards, who could survive 4 indictments, then until they finally convicted him, I think on the 5th. Who actually ran on a slogan that was "Vote for the crook." It's important. Unless you could dodge it like Edwards or dodge it like Billy Boy, you better have an impeccable life history. Otherwise, you got to play ball with the power players. And Gaetz was very aggressive at not playing ball with the power players. But here's the main reason I am suspicious of all this. So aside from that Greenberg fits a particular type I've dealt with in the past in my legal practice, try to tell people to be careful of these kind of people. Be careful. I don't go to certain invites for a reason. You got to be careful of these settings, these situations, these circumstances. But people underappreciate that. And I think Gaetz might have been a little naive. If you're going to go after the deep state, you better make sure all your ducks are in a row. That's just a word of the wise.
No, I mean, and people are asking, like, what's the difference between Gaetz and Swalwell?
Swalwell was sleeping with an actual spy. That's the difference. While he's on the intelligence committee.
I'd say at this point in time, the evidence is somewhat different. On the one hand, it's a little bit stronger than on the other. But
it actually relates to his governmental duties. This does not relate to Gaetz' governmental duties. And I suspect it's going to turn out Gaetz had no idea. And I think what you saw was Gaetz kind of panicking with Tucker because he's not familiar with this. This is uncharted territory. He's not, people who are criminals are the ones who lie well. People who are not criminals tend to come off very poorly in their first interviews. I've experienced this with many, many clients. The more innocent they are, the worse they come across initially. But here's the thing. When some of the names started popping up, that's when I got curious. So people connected to the Levinson case, which are a bunch of ex-deep state type people connected to certain to embassies that somehow Scott Adams ended up in the middle of this. Some guy connected to a consul was like texting Scott Adams about this stuff. And then those texts got publicly disclosed ultimately. There is clear evidence of the extortion from the texts that have been leaked.
So I brought up that chat. It was someone made the comment. Yeah, the Gaetz' dad apparently was wearing a wire, or apparently indicated.
No, the prosecutor confirmed that. The prosecutor confirmed that he was wearing a wire on his back. This looks like there's an internal fight within the Justice Department. Mm-hmm. You have one wing going after Gaetz. You have another wing trying to protect Gaetz, expose the extortionist, and you got a former high-profile DOJ attorney connected. And if people just look up, Google. Well, don't Google. Go to DuckDuckGo. Go to DuckDuckGo and look up Levinson, Mueller, Russian. See what pops up. And how do the same people connected aspects of Russiagate show up magically here? So the extortion may have been a trap. It may have been once he pays this, we know he's guilty, and we can let him still pursue it and take the money and run with it. They do that frequently.
Or I think it was Tim Pool's hypothesizing and others that they knew it wasn't going to go anywhere. They knew that it was going to get leaked, so they leaked the accusations, knowing that the extortion was going to come up because ultimately,
I think somebody tipped him off that there was a wire, so they needed to jump ahead of the story. And by the way, that's a sign somebody inside on DOJ is leaking to their friends and pals outside, and these are people connected to Robert Mueller, connected to billionaires around the world. They've been using the Levinson's a guy who the CIA sent over to spy in Iran, and almost everybody knows he's dead. His own family's declared him dead. But there's some grifters that have been using it as an excuse to raise millions and millions of dollars for years now, decades now. And you research some of these people that are connected, and they're interesting. They're like out of a James Ellroy novel, Buzzer Rover or the Cold 6000. Like you say, when it starts to fit the Ellroy script, I start getting a little skeptical.
But it's not, it's not even the Ellroy script anymore. I've lived through it now in real time with the Flynn script. Once you do not trust the FBI, and once you know how fundamentally corrupt they are, and once you know how fundamentally partisan corrupt they are, okay, I first of all, I'm always innocent until proven guilty, despite my own personal opinions on specific issues. Swalwell, I waited even still, gave the guy the benefit of the doubt until explanations no longer made sense. But when you have the FBI now seeing how they work, going after Gaetz, if he's guilty, he's guilty. I mean, he has to be smarter in any event, knowing what Washington is about, doing what he's doing. If his defense was, I knew there was a very big age difference, but I thought she was, over the age of majority. Okay, you're still really walking on, you're walking on a thin line. But
if my view is, if she was complaining, we would already know about it. If the photo of her suggested someone that was younger than 20, we would, I bet, already know about it. So that's why I suspect, and that's what makes me think not a coincidence necessarily, that it may have been a trap all along, a trap by someone who just wanted extortion material. Then when he got into trouble, Gaetz doesn't bail him out. So then he goes to other people to help try to get at Gaetz, try to help get him out of his own problems. And by the way, this pitch is made when Biden was vice president. People close to Biden would make the pitch to clients of mine that, hey, if you pay this amount and you do this, we'll take care of that. And I made sure they didn't get anywhere near that, the 10-foot pole, because 9 times out of 10, folks, that's a trap. There's no final extortion payoff. Either it keeps coming, or they use the fact of the payoff. I told a client this many years ago. I said, this is a trap. Don't do anything. Don't agree to him. Don't talk to him. Don't meet with him. And it came out a year later. I was exactly right. The feds sent this guy in to extort my client, knowing that's what he was doing, under the guise of a civil settlement plan, and had him in an undercover wire. Unfortunately for them, my client didn't show up. And they didn't get what they wanted, but that didn't stop them. I mean, I
don't know if anybody else has gotten this, the spam email. We accessed your video camera and we have incriminating video. Send us Bitcoin, or we're going to release it. And so I was like, I got one. He's like, okay, first of all, you don't know me. I don't care. But the second is like, how do they make money doing this? And how does anyone who pay them expect them to then leave them alone after they pay them? And so I contacted a buddy who's in IT, or I don't know what you would call this, security. And he says, you can look at their Bitcoin wallet to see how much they've been paid. And it's, people pay this. I mean, it's hilarious, and also kind of sick that anyone who thinks you're going to get extorted once, you're not going to get extorted once. That satisfaction of the extortion demand is itself extortable. So it's the way the mob works. It's the way extortion works. So, a bad idea from the get-go to think you can pay off the extortionist. But the
fact that he didn't pay a dime or offer a dime does suggest to me that he doesn't think he's guilty of anything. Because, I mean, that would have been an easy thing to do at some level, or negotiate behind the scenes.
Well, 25, in fairness, 25 million. I don't care how much FU money you have. That's a lot of money. So maybe
yeah, but not when it's like less than 2 pennies of your wealth.
I don't understand how these flipping politicians get so bloody wealthy in the first place. It's the carriage is in front of the horse again. Gavin Cross, thanks for the sanity. Here's the Glenfiddich on me. Thank you very much. I have gotten into gin these days because whiskey, I feel like I've gotten too old for whiskey, or scotch, I should say. Now
that's because your brother-in-law makes really good gin.
It's amazing, but also, now you're making.
I'm just not a gin guy. That's like a London man. In London, all they talk about is gin. It's like gin this, gin that.
No. I just find it is easier to drink than scotch, but I love a good scotch. We got feds originate this stuff too often. Yeah, like I can't help but look at it and say the timing is odd. I take the allegations seriously. Gaetz's response to Tucker was a little peculiar. Whether or not it's guilt or nervousness, I've never.
It was nervousness. A guilty guy knows how to respond. That's what I'm saying. Like I always tell people, don't read into the things that you think. The innocent guy will come across all over the place because their emotions are going like this. The guilty person will be calculated. I mean, look at how Bill Clinton responded. I didn't have any relations with that woman. So that he was ready to lie. He was comfortable lying, at ease lying. That's what criminals are. Because criminals have been thinking years in advance. What am I going to do? How am I going to explain? What's going to be my story? It's innocent people who don't know what to do. They get caught, that feel guilty maybe about something. Great first cinematic reference, Under Suspicion, with Gene Hackman and Morgan Freeman. And watch and we'll understand why false confessions are one of the most unreliable, why confessions in general are one of the most unreliable forms of evidence. You shift guilt and culpability. There's so much emotionally going through a person who's innocent that comes through that makes them look like a wreck, whereas the guilty people lie with ease and smoothly.
We got Dad Bear says, this time last year I was looking at careers in the FBI. I now view it as the most partisan, corrupt, terrifying entity we have. And by the way, anything happened to Kleinsmith, the felonious guy who never got a day in jail? Has he been?
Not to my knowledge. Not a single thing. Well, they're busy chasing Sidney Powell and chasing Rudy Giuliani around for their election controversies, trying to get him disbarred or sanctioned everywhere. No, nothing with Kleinsmith. And of course, as Trump hilariously put out this week, he goes, "Is John Durham a real human being? Is anybody sure that guy's alive? Is that maybe a fake name?" Just to remind everybody of what's how no consequences. And like I said, if there weren't a bunch of people that showed up with those ties and connections, I might not have gone all James Ellroy on the Gaetz case. But once I saw them, I was like, Oh,
no, there's no question. I actually just want to bring this up. Totally unrelated. Hit turbine. What the hell kind of glass is that, Barnes? That's a proper snifter glass, by the way.
Yes.
Narrow at the top. You heat it up at the bottom. It comes
and
up.
What it does, it rotates around, so it helps rotate the whiskey or the scotch or the cognac.
And by the way, when you put that on the table, it doesn't spill over. It naturally.
I know you think it will, but it doesn't.
Yeah. So. Okay, so Gaetz, I mean, to be continued. It looks timing's fishy. The fact
he needs to lawyer up well, and he needs to get a good PR team in, and he should have already done it. But by the way, it's more signs the guy's innocent. This guy wasn't preparing like a guilty guy. This guy didn't react like a guilty guy. He didn't pay off the extortionate like a guilty guy. His problem was he was a little naive about the people he was going after. He was a little naive about the deep state apparatus and the powerful people in the Washington establishment, or whatever you want to attribute it to. This is a guy who'd been attacking FBI corruption. Let's say it was just limited to that aspect. Those people have power and they retaliate all the time. And he was just maybe a little idealistic about that.
Well, and some people might say naive, and others might say arrogant, cocky, because he thinks he can get away with it, depending on how you view it. I happen to think, dude, he's relatively young. Although I think I would never necessarily get into this because I deeply distrust based on what I've seen and what I've learned now. So if he didn't think he could possibly be at the crosshairs, the political crosshairs, yeah, naive would be one way to say it. And speaking of guilty people and how they might respond, hey, spoiler alert, I think everything in Hunter Biden's brief response, I haven't seen the whole interview, I think all that was 100% a lie. I think he's guilty.
This would be like if Matt Gaetz said, well, they might have been underage. I might have been there, but it might not. And it might have been Russians that put him there, or maybe it wasn't. Or maybe somebody stole something. I mean, that was one of the worst lines. The behavior panel will probably stay away from it because of politics. They did a great version of breaking down Meghan Markle and what a complete hopeless liar she is. And people can watch that video at the behavior panel. But they would take this apart piece and nail. This was like even Jimmy Dore just couldn't quit laughing. All he did was show it, and then he would just laugh for 5 minutes, show it again, laugh for 5 more minutes, show it again, laugh for 5 more minutes.
It was the most outlandish thing I've ever seen. And like I said in my video yesterday, when he says, for real, can you imagine an adult when trying to convince someone else of the truthfulness of the statement saying, for real, it really happened, it did? I mean, it's straight up.
That would be something like your littlest one would do. For real, Dad. For real. I'm telling the truth. For real.
When they say that, anybody with kids will know when they say that, it's not for real. It's kids don't, you don't call them liars to their faces, but kids lie all the time. And the trick is when they're lying. Is there any way for the FBI personnel to be held criminally liable if they're uncovered to have known about illegal Hunter laptop materials but stayed silent? Same idea with Gaetz.
I mean, look at what happened with Spygate. So when there was no consequences to that they get rewarded for. People can watch to give a sense of the history of the FBI, the latest episode of The Deep State. That's at vivabarneslaw.locals.com. And if you understand the man who founded the FBI, who their FBI building is still named after, you'd understand how they really tend to approach these kind of cases. And sadly, consequences rare. That's why the CBS sits him down and apparently didn't ask him about his tax charges, didn't ask him about the corruption charges, didn't ask him about what was on that laptop, whether that was actually the case, not just generally about the laptop, and didn't even ask about any follow-up about his lying on the gun registry form, apparently. So all of these crimes he's getting to walk from, serious crimes, substantial crimes, repeated crimes. And for folks, if they really cared about certain activities, they would follow up on certain photo images that are on that laptop.
We've said it repeatedly multiple times. There are only a few good reasons why a computer repairman goes straight to the FBI after having preserved a mirror copy. Very few reasons, but that is conjecture, hypothesis. How does he even agree to this interview, by the way? Just from a perspective.
Oh, he's marketing his book. He's got a new book deal. He probably got a big fat check. One of the best ways to launder bribes to politicians is book deals. So and people should look up who some of the publishers are. That's going to be probably a future, maybe a Deep State episode or Hush Hush episode. But some of these, people would be surprised some of the origins of the wealth of some of the big publishing companies behind books that maybe even Barack Obama was paid to do. It might be a little unsettling.
All right, I'm bringing this up. eHonda 420 says, hey, Viva, I love the podcast. I do a show on my channel called, okay, I'm not trying to get in trouble. Name says it all. Do you ever wear a tinfoil hat, sir? I try to avoid outright gimmicks because they never look good, even when people do them as a joke. It's one of my things with AJ. Some of the gimmicks just don't age properly and they don't get received properly. But I stick to authentic words and what I mean, and hopefully without the gimmickry, except for this nice shirt. What do we want to move on to now? So Gaetz, we'll see. We need more information. The timing of these things seems very suspicious. The timing of the charges seems suspicious. The accusations, I should say, and the evidence of extortion. It's going to be up to everyone out there to interpret what came first, the chicken or the egg, or whether or not this is all part of one scrambled omelet here. But it's fascinating. Okay, let's see here. We got some good ones to cover before we finish. The next one that came up, Cheerleader goes to SCOTUS. I guess we totally unrelated to the Gaetz, but it was next in the list. So for anybody who doesn't know, SCOTUS does not want to take up certain lawsuits, certain petitions for cert, but they've taken up this one, which I think is, in my humble opinion, so much more clear-cut and easier to answer than the one they refused. But that's my personal opinion. The essence of this story, for anybody who doesn't know it, it's a 14-year-old girl who's trying out for the cheerleader team. What happens? She doesn't make it. She gets angry. She goes on Twitter or Instagram on a Saturday night and she says, F cheerleading, F this, F the school, F everything. The school catches wind of the Instagram post because another cheerleader on the team shows it to her mother. Her mother happens to be one of the organizers or whatever involved in the cheerleader team, takes it to the school. The school disciplines her. What do? Did they suspend her, Robert?
They took this. I don't recall the scope of the disciplinary action. I just recall that it was disciplinary action.
So they took. Yeah, go ahead.
Legally, it's their new theory, and this will relate to another Supreme Court case we'll bridge into, but this attempt of the government to keep expanding and expanding and expand. Every time they write a little loophole, the Supreme Court does some little loophole, whether it's the First Amendment or the Fourth Amendment or the Fifth Amendment or the Sixth Amendment or the Eighth Amendment, inevitably, it's going to swallow up the rule. And that's what's basically happened here. They've just the schools, public schools uniquely, can control speech of students for the limited purposes of maintaining decorum at the student on campus. Then they decided, you know what? Really, we need, in order to maintain equilibrium on campus, we really need to be able to punish all of a student's speech, no matter where it's made, no matter when it's made, no matter how it's made. And they decided to say that they're trying to use this case because they lost at the circuit level. They appealed it to the Supreme Court. They want the Supreme Court to expand the rule to say, school, if your kid goes to a public school, they no longer have free speech. They can now be restricted and restrained in whatever way makes the school feel safer. And we already know how that emotional safe space nonsense works. So they're trying to extend their power. They're another example of the state trying to expand their control over the population using public education as its means to do so. The circuit court made the right decision, said no, you get the right to regulate on-campus activity. And if somebody's, say, right across from campus doing something, then maybe that could be considered impacting the campus in such a way that you can regulate it. But it doesn't mean that every time they're on social media or they're hanging out in their house or they're hanging out at a bar, cafe, or restaurant or wherever else, or church, that suddenly you get to regulate all their speech because, by golly, their speech might be heard later on by the students, which might impact students.
No, and so just people appreciate this. The school lost. They didn't go straight to appeal. They didn't go straight to SCOTUS. They went through appeal. So they lost on the first two. They lost at the first two levels, appeal to SCOTUS. And their argument, like Robert said, is that it's disruptive to the school, these expletives that she put on her Instagram page. Now, the girl and her dad and her lawyer did an interview. I don't know where it was. Nate Brody sent it to me. She's very smart and she was very well prepared. And in her interview, she says, "Look, I wasn't wearing school uniform. I wasn't in my cheerleader outfit. This didn't reflect. She didn't say this quite so eloquently. She didn't reflect on the school, but I wasn't in uniform. So this can't be like interfering with school business. This was on my own time. And the school is trying to say, like bullying, like disrupting at school or something that is specifically targeting the school. This can be disruptive. And the lawyer says, this has, this is an expansion that has nothing to do with the school. And this is not what the court, it was suggested by way of precedent. And it seems, again, like a clear-cut case that the Supreme Court is going to come down one way on. I don't see how they would overturn the two previous decisions, which were extremely well motivated. But just so everybody appreciates the absurdity of the school's argument, like bullying. Well, first of all, bullying is far more directly involved in the activities of the school. But even then, you still have laws to deal with these things, that if there is some activity among students outside of the school, in theory, there are laws to take care of that already. Things that directly target the school, it's already covered. Things that are done in the school, it's already covered. This was not targeting the school, not in any sort of school attire, not in any identifiable elements, just someone on their social media. And the school says we want to be able to reprimand, which basically means track their social media and do whatever we want if we think that it's not just directly interfering, but offensive and indirectly. It's so over the top. But, I live in Canada where, in theory, you can get arrested for social media posts. So, I mean, how do you see the court coming down? How do you see the split? Because I'd be curious to know, to see if there's going to be a split and to predict on that split.
So, I mean, to give an example, in the child sexual abuse cases, the Supreme Court was unanimous. Thomas wrote that opinion, and they reversed the lower court. So when the law is clear, they tend to be unanimous decisions. So I think this will be close to a unanimous decision. I think they took it to overturn other courts that have ruled the other way in other jurisdictions and make clear that just because you have some authority over a person that's in the classroom doesn't mean you get to govern and regulate a person's private life. And that they have to draw that line more clearly than they have before. And I hope they took the case for that purpose. And I believe that will be the resolution.
Yeah, I mean, I don't see the pretzel logic that one would have to go through to basically give. It would be nothing less than carte blanche to schools to survey and, dare I say, spy on social media. Because, anyway, I mean, that's what it would be.
It would be thought control. Because, I mean, this is ultimately going to be, you can't say anything offensive. This is going to be, you can't say anything offending. You can't say anything disrupting. So it's going to extend to politics ultimately. And they'll say they're not regulating political speech. They're just regulating offensive or disturbing speech. That's where they're trying to go.
We're definitely, I think we're going to go past 2 hours here, but we should give 10 minutes to Artur Pawlowski, which, Robert, I think you saw it, the pastor in Calgary who lost it on 6. Look, we're arguing as to whether or not they were 6 police officers or whatever functions they served, but 5 of them were in uniform, and there was a health inspector, whatever the person's title is. 6 individuals come down on a church, and it was a Orthodox church. It was not. He said Passover, but it had nothing to do with Judaism. This is a Polish Orthodox pastor celebrating Good Friday, and 6 cops come. 5 cops and 1 health inspector, because they're not apparently questionably respecting the health guidelines that were issued for COVID protocol. The guy goes, I want to say nuts, because I could feel the rage, and hearing him get enraged, I felt the rage. And I felt good hearing him get enraged. It was a guttural, passionate reaction. I did not like the names he called them, because I think that cheapens the that sort of it lessens the discussion. But this guy is from Poland, and if he knows a little bit something about the accusations that he was leveling, he knows what it's like to be raised in a repressive regime where police come to intimidate and interrupt Good Friday services under whatever pretext. And he says, get off, kicks them out, says, you're not welcome, get out, get out, get out. They take their sweet time, but get out within a matter of minutes, maybe. And the question, one question is whether or not the police were committing a crime. Ezra Levant, Rebel Media, rightly pointed out, section of our criminal code, 176 second paragraph, so it's a crime to interfere with a religious service. Like my personal belief is Ezra is right on that aspect of the law, but my reading of the Quarantine Act is quarantine officers can do whatever the heck they want, and they can issue whatever directives and instructions they want if they think it's necessary under the Quarantine Act. And forget the criminal code, be damned with your civil rights. So I think they could find ways to override or find exceptions to that provision of the criminal code. And I think it's unconstitutional, but I think the Quarantine Act allows for it as drafted. But they left, to be determined and to be seen if they come back with a vengeance. But here we have pastors flipping their lids and defying these orders, but you have the police and the courts enforcing them. Excuse me, internationally, it seems that at least for now, some of the courts are saying, no, these measures are not going to go. So, Robert, that was the Canadian side. Take us into the international side.
So, yeah, there were courts in Austria, courts in Finland, courts in Belgium, and maybe another place too, that maybe it was Germany as well, that pushed back either on PCR testing or lockdowns. And what they're starting to do is where the evidence, just like the Stickman case, which is, again, the only lockdown case I know of anywhere in the world to take meaningful evidence and hold a real trial on the empirical basis, the evidentiary foundations of these orders. And as what Judge Stickman found is that under any interpretation or legal standard, these orders are not rooted in good evidence. And what's happening is, as people see more political blowback, you're seeing courts start to get a little bit more brave, and you're seeing more cracks in the judicial dam of allowing the state to continue to do whatever they want for however long they want. As prominent politicians like Whitmer in Michigan, like Cuomo in New York, like Newsom in California are in political or legal hot water and they're the most high-profile lockdown governors in America. Right now, Macron in France is in serious trouble. There's already talk that he may lose to Le Pen, which nobody thought that was even conceivable in France because of the response to his lockdown politics. So you're seeing courts say, at a minimum, like in Belgium and Finland, the legislature's got to pass it. No more of these random edicts for years. Just the we have a legislature for a reason.
And to interrupt you there, I guess that is a victory. Like I was irritated when the Hague decision, they issued the Hague decision, they overturned it in appeal, but in the interim, the government does, jams through the law anyhow, so that any outcome is moot. But at the very least, I guess it's a victory of sorts. You force the politicians.
You got to have the legislative branch responsible for these things, because if they would enforce that uniformly, there'll be a bunch of places where it won't happen. In Wisconsin, the court overturned the mask mandate, the governor, because again, they hadn't gone through the right legislative process. Why? Because the Wisconsin legislature won't approve it. And so in more and more places, you're seeing courts push back against the irregular means by which these things went through. While the substantive problem, I look like Pence there for a second. The substantive problem is, in my view, the lockdown logic itself. There's a big constitutional procedural problem in that this not going through the democratic processes it's supposed to go through. And it's good to see the courts at least enforce that much. The other thing they're doing is courts, and this is thanks to a member on our locals board, because I was made aware of these cases because the mainstream media wasn't talking about, and a lot of other people didn't know it because members on our vivabarneslaw.locals.com board were the ones that made me aware of it. Including interpreting and translating a decision, I think, out of Austria. And they started also to question the PCR testing. So there have been doctors and people in the medical community, including one of the people who helped create PCR testing in the first place. And I think I got the acronym right. If I didn't, you can tell me in the comments. But if you want to troll me, the only way you guarantee to read is to go to vivabarneslaw.locals.com. There, I'll actually definitely read your comment. But is that these PCR testing is not adequate by itself to measure whether someone actually has COVID. That there need to be other symptoms, other signs, because when they're digging into the actual evidence, they're not finding actual evidentiary foundations to levels of medical and scientific and legal probability and certainty to justify the intrusions on people's privacy that are occurring.
I tweeted out, I never expect to get a response anymore because I recognize on Twitter I may have become the monster that I'm trying to battle, but Twitter is just snark. You can't draft politely on Twitter anyhow because it never gets read politely. So you may as well just draft with snark. Ford in Ontario locking down the province again. And his justification, the cases of the new variant are up 10%. I said, Ford, don't give us cases. Just tell us ICU, hospitalizations, and fatalities from this. And I said, I know you won't because I happen to know what they are roughly. If they were to go by that, people would revolt. In Quebec, we've even lost the dialogue anymore. We're still under curfew, and we hear, the variants, new cases. But that's not the relevant aspect of this. And so I don't, the PCR, I know what people have said about the PCR. It was never intended to do what they're using it for. I'm not the scientist. I don't know that. All that I know is from a legal analytical perspective, when someone is giving you one number to justify their actions, but not what is objectively the more relevant number, then I have more questions. But what's going to happen in Europe? It's going to happen again. They'll either successfully jam through some laws to remedy the legislative deficiencies in the edicts they've been renewing month over month, or maybe successfully they won't, which will be an even bigger victory. But at the very least, it's going to force the politicians to do what they should have done in the first place and then be held accountable for it next election cycle. My only thing is, I know everyone I talk to privately in Quebec has had it. They're fed up and they don't believe. They think it's been overboard for a long time, but publicly people don't seem to have the courage or have the platform to speak up. Or I don't know if I'm just talking to the people and they're being polite when we talk. But it seems that there's a lot of people who support this stuff, which
that bridges. I mean, the other dangerous place they're going now, of course, is vaccine passports. And there's been some good pushback, and Florida and some other states are putting in laws so that nobody can even try to do vaccine passports within their states. But the UK is talking about them. Employers and private businesses are talking about them. Biden is talking about it. I think there would be major problems with trying it at a federal level. But I think that I've been researching it for a while, and it's in the preliminary stages. But I do think there's a way to legally sue to push back against these vaccine passports as to both areas of public accommodations and employers. Not necessarily airlines, because there's a law that prohibits them from discriminating against certain people, but it's unenforceable unless the Secretary of Transportation does it. And I don't think Biden's Secretary of Transportation. Oh my goodness, is that Buttigieg? Oh, we're totally screwed. He's the guy who's biking to work every day. And of course, somebody unfortunately caught him. He wasn't really biking. His SUV was dropping him off just like 2 blocks before he took the bike ride.
Thank goodness for the internet, because it exposes the absolute. It's so insulting. He got out of an SUV, gets on a bike, the SUV still follows him. And this is true. It's more important to give the symbol of energy saving than it is to actually do it. And okay, no more. I won't. Yeah. It won't. And by the way, you can't criticize it. If you criticize it, you'll be attacked. You'll be accused of being a ist or a phobe, whatever. Because identity politics makes it impossible to address the issue, because everybody else accuses you of addressing the person when the person has nothing to do with the issue. But it's an
example is, because I'm pursuing these ADA suits under the discrimination laws for these various mask mandates being enforced against people who cannot wear the mask and are actually exempted from the rules by definition of those rules. I remembered the HIV cases. So what happened was, when the HIV scare happened and nitwits like Fauci were running around saying you could get it in your kitchen, that's the kind of genius. That's the guy we're still listening to, folks. Go back and read some of the insanely dumb things that guy said about HIV, but about AIDS. But it led to a good set of legal precedents that a bunch of employers panicked. And they're like, well, we're going to test people, and we want to know whether they have HIV. We're not going to, we're in the public accommodations business. Whatever, we think you can spread it anyway. Hey, Fauci's saying you can't. And it led to good lawsuits that they lost under the ADA grounds, because the ADA describes any medical condition that's perceived as a disability. It doesn't even have to actually be a disability. And so my view is a vaccine passport is impermissible legal discrimination against people in cases of public accommodation and employers under the ADA and under the various state analogous provisions. It may also implicate things like the Fair Credit and Reporting Act. There's a bunch of limitations on employers, the Family Medical Leave Act, that restrict what they can do in the medical space of their employees. Now, HIPAA doesn't prohibit them from getting the information from the person voluntarily, but it could create complications if it's mandated, whether they can do so. Can't disclose it to other parties. But there are limitations on what medical exams they can do and what they have to prove. This is what's great. It's the same standard. If people want the broader debate of vaccines, go back and watch Viva, and Dershowitz on that. That's the whole debate about vaccines and whether they can be forced in general. But as to this issue, what's nice is the ADA law requires you to prove someone that if you're testing or limiting employment or limiting access to accommodations based on something related to their health, you have to prove that they are a significant risk of substantial harm. They have to be a direct threat, And I don't think the evidence will prove and substantiate that in the vaccine passport context. So I'm looking at suing. I'm looking at suing, and there's some people who cannot take the vaccine that their doctors already told them it's too dangerous to take it for their particular condition.
I have a family member who that applies to, and now this person, the family member is terrified of the virus and upset they can't get the vaccine, whatever. But no, there's people don't appreciate that. There's cases of people who can't take vaccines. And I like I said first of all, I actually want to bring this up because they're hoping that the passports will fail for being over the line so they can accept mandates that are only slightly over the line. We had this discussion in real time with the defund the police. And we said it was such a preposterous statement in the beginning. But first of all, you say it for long enough and enough times, then people, come around to a lesser extreme version. But over time,
it's going to be more severe. They're going to say that there's too easy to fake vaccine passports. One of our locals board members came up with a funny idea. They said that, it's like mail-in voting is very safe. So just mail me the vaccine. And don't worry, I'll sign. We don't do signature checks anymore. I'll say, don't worry, I took it. And you can give me my certificate that if it's good enough for voting, it's good enough for vaccines. Being somewhat humorous.
And I, being somewhat sassy on Twitter, I say, history, Mark Twain, history doesn't repeat, but it tends to rhyme. And when we look back at all of these laws that ended up having the most racially discriminatory effects, I don't care the politics. They came from the Democrats and, Jim Crow laws and whatever. But we're seeing in real time now how a law is going to have a racist effect.
Well, that's the second aspect. It's going to discriminate based on age because it's going to discriminate based on race. It's going to discriminate based on perceived disability. So I'm going to look at attacking it every which way, going after these public accommodations, going after employers that try to impose it, going after public educational institutions. Going to be looking at bringing, 3 to 5 select set of cases like the mask mandate suits, because I think we have a viable theory based on the HIV/AIDS precedents to really go after them. Because I don't think they'll be able to prove what they think they can prove.
No, and people don't appreciate this either because people may know the stats. Blacks and Latinos are getting a fraction of the vaccines that are whites, and not because of availability, because of preference, because of a deep-rooted distrust in the government for reasons which anybody who's slightly informed would know. And so, now you have, on the one hand, a political party that doesn't want to have voter ID laws, that is allegedly the racially tolerant and the non-racist party, wants to implement a vaccine passport, which is the antithesis to no voter ID laws. And it's going to have a clear, unless, they make it mandatory that ethnicities and certain races have to have it, it's going to have a massively disproportionate impact in terms of freedom of travel, freedom of civil liberties, like the Dr. Leanna Wen was saying on CNN, of certain ethnic groups. And it's a bizarro backwards world. There's nothing else to say about it, except you need to have a certain amount of information to know how backwards, upside down it is.
And that's a good bridge into the Georgia election law. The Georgia election law is pretty modest. They still allow no excuse absentee balloting. The main restrictions on it are that you have to have they took away the most egregious aspects. You can't bribe people while they're in the voting line. You can't bribe an entire election office by saying, "Hey, I'll give you $500 million if you do this in the election," like a certain famous Facebook owner did in the last election. You can't have as many drop boxes everywhere, so you can't flood the system with ballots and flood an easy way for the ballots to come in without some chain of custody, because they can't even find 400,000 ballots still in parts of Georgia. And within the chain of custody. And so the rules are far less onerous than New York. And yet these people are screaming bloody murder, which I find confusing because they all told me that these rule changes had no impact on the 2020 election. So why is Biden and everyone else screaming bloody murder?
No, bloody murder and again, throwing out the accusations of voter suppression and then always playing the victim.
And that's partially true. It's going to be much harder for dead people to vote next election.
It is always using the victim, not as a victim, but as a political tool, as a political pawn. And who was it that I said something relatively undumb about? Oh, that certain politicians, they never see a victim for a victim. They see a victim as a pure political opportunity. It was the incident that happened in DC. But they're saying like you can't give food out. Oh, it's going to be terrible. People are going to not have food or drink in the line, when it's just quite clearly to prevent what we saw videos of, but we can't discuss it anymore. Of using.
Yeah.
Hey,
Well, in the old days, not talking about the 2020 election.
if it's ever in the history of the U.S., Robert, has now been off limits.
That's true. Well, in the history of some place somewhere in another time, in another galaxy, the way in which they used to hand out whiskey bottles to people while they were walking in, and you'd give them their ballot too. There didn't used to be a secret ballot, so you made sure they could vote a certain way. And our mail-in voting system arguably created the same thing. But the only limitation, Bill Gaetz has sent a fly to harass me because I talked about vaccine passports.
Oh, wait for the memes tomorrow. We saw what happened with Mike Pence. You're going to have a fly meme tomorrow.
Yeah, it's either that or talking about the deep state and Matt Gaetz. I totally apologize. I have no idea. If anybody sees this, it was my twin. It was the twin Paul. I'm Paul. Robert Barnes had nothing to do with it. Totally innocent. Totally innocent. The whole nature of it is extraordinary. But for example, you can still bring water and food. You can the political parties can give it to the election offices to give it out to people. The election offices can make it available. And it's not like people are dying of thirst. You don't have to walk through the desert 40 miles to get to vote. So this was totally made up by the press and by the media. And these are just modest reforms. Again, this is nowhere near as strict as New York is.
Do you need to get an ID to get a vaccine? Yeah, you have to show proof of residence too.
You need an ID to get on like American Airlines or Delta, who's complaining about IDs for absentee ballots in Georgia.
It's madness. It's just absolute. It's idiocy. There's no other word for it. It's idiocy, and this type of stuff only works. I'm not saying on stupid people. It just works on people who just don't know. And it's not even a question of intelligence. It's just a question of experience and age, or the willingness to read into that which surpasses your age, because knowledge is just experience plus memory. And which is why young people, they lack the experience, but they might have the memory. And why some old people, they might have the experience, but they might lack the memory. I'm going to write that down. I just made that up right now. Pretty good. Okay. We've gone over our time, but let's just see if we have the one more. We've got to do the sue the Fed, Robert, because
that's what I was say. So real basic. I mean, people can look it up. George Gammon came up with the idea. So he's willing to be George Gammon versus Federal Reserve. And what is the Federal Reserve? The question is, how do you audit the Fed? Well, the goal is to sue the Fed in order to audit the Fed, because the Fed is subject to the Freedom of Information Act. After 2008 and 2009, Bloomberg and some other big media networks sued the Fed, and the Fed used to hide their documents in different sub-constituent banks and board of governors of the different reserve banks, and say, hey, they're not subject to FOIA. Well, they lost those cases. They said, nah, you are. And very few people have followed up. So we're going to look at sort of a dream list going all the way back to the history of the Fed of all the information and documentation you would like. And I have some bank people involved in this too. People who used to be bank auditors, so they're perfectly situated for this, as well as some politically minded folks. And we're going to crowdsource part of gathering the information. What do we want? We're going to do FOIA requests. If the Fed refuses, we're going to file suit everywhere that they refuse. And either they turn over the documents and allows us to audit the Fed, or they say, you know what, this was outside of our statutory authority, so we don't have to turn it over. And we use that admission to bring further suit, because it looks like a lot of the Fed's activities are outside of their statutory authority. So it's always uphill when you're going up against the Fed, but it's time to be David and throw some rocks at Goliath.
Well, and I've heard people clamoring for audit the Fed for a decade. I mean, for as long as I've been relatively conscious about the political side, you are crowdsourcing it. So let's get that
already fundraised. So George Gammon matched it, was going to match every donation, raise the funds within 6 hours for the first stage of the cases.
Crazy. And just so everybody out there, it's fully transparent. Gammon set up the account, beneficiary Robert Barnes to act as counsel to do this suit. Gammon matched every dollar for dollar, which is why they got to 100,000 within, I think it was 36 hours. So and
the goal is to show we can crowdsource individuals to go after the Fed, to sort of take the GameStop example of going after hedge funds with Wall Street bets, take the same example to show other lawyers that I'm doing this on a sort of a discounted level, but the goal is to show other lawyers this can work, so we can get more lawyers, more legal advocates willing to go after concentrated institutional sources of power using things like the Freedom of Information Act to do so, because we're just seeking information that might be highly educational. So it'll be a fun little suit.
Anyways, and if and when, I guess we'll get into it in greater detail, but just so the awareness is out there, Barnes and Gammon have a GoFundMe. I guess I'll put the link up. Oh, geez, I haven't been doing it.
No, you don't. It's already closed.
Okay.
So we'll do a new one in the future. The goal is to be ahead of the curve before someone can try to shut it down or anything else.
And anybody who's going to criticize Robert for doing the GoFundMe thing, and This is what a transparent GoFundMe page is. You set the goal and you don't let it get to $1 million if the goal was 40,000. I mean, that's
and the goal is to show it as an example for other people. So I was willing to do it at even more discounted level, but partially George's idea was we should show other lawyers, hey, there's enough support out of this, so you don't have to depend on one or two people to help fund this. You can make this a template that other people can utilize to also be successful challenging it. It's, again, to take that same crowdsourcing mechanism that a bunch of little Wall Street bet nerds used to take down one of the biggest, most corrupt hedge funds in America. So if they can do it, we can do it. And I want to show the example so that other people will do it. And that's the goal. It's the same with the locals. The amount of time I spend on locals is not economically rewarding compared to the my legal time.
Robert,
but I want to show an example so everyone else can copy it, so we can take on big tech successfully.
And not only is it not economical for you, it puts pressure on me because I'm nowhere near there. I'm going to try to do better. But you've set an impossible bar, so I can say right up front, I have abandoned any expectation or hope of reaching that bar, but I'm going to do better. And I want to just bring this up here, like Rebel, who crowdsources as well. Everybody should check out Rebel News, Fight the Fines, and there's one fightthefines.au because they've gone nuts in Australia as well. It's crowdsourcing, and as far as I know, Ezra Levant and Rebel Media are extremely responsible with it. So it's not. You can call it a grift, and that might just be an ignorant statement. Thus far, there have been no alleged improprieties. The accounting is tight from what I know, and it's just a good way to allow crowdsourcing for people to contest these tickets that they've been getting that are over the top.
And it's critical to be a counterbalance to everything. I mean, Kyle Rittenhouse able to mount a defense because of it. To that earlier super chat question, Lynn Wood is no longer involved. And I don't have any other comment. I'm trying to resolve certain things with that, so no other comment on that. Okay. A question from... We answered most of the locals' questions topically, but from QMass, what about tax money going to illegals? As long as the Congress authorizes it, there's nothing illegal about it, even if that's politically problematic for many people. From Apollo's Pat. That's interesting. Mm-hmm. I may have misspelled. Maybe Apollo's Pet. The asking about the difference between the bakery and big tech, the Colorado bakery being harassed again. It's because the state law applies to the bakery, though there's constitutional restraints on that state law, whereas there is no law right now that applies to big tech because of Section 230 and their discrimination, politically motivated discrimination. And we answered the question about the vaccine passport. And from Eurolocates, I believe, can a judge set aside a jury verdict in Minnesota? If it's like the federal, I haven't researched it in Minnesota specifically. In most jurisdictions, a judge can set aside a verdict as being against the evidence and order a new trial. That's partially what happened in that related Flynn case that the Fourth Circuit just overturned and reinstated the verdict. It usually depends on when the judge does it. If a judge does it before the jury returns a verdict, that's often considered double jeopardy and the prosecution can't appeal. But if he does it after a jury verdict, then it is appealable, can be reversed on appeal. So that's that answer.
And one other thing, actually, before I get to this one, everyone hit the like button, right? If you want to subscribe. If you're not, if anybody's watching and is not subscribed, that would be shocking. And just to cause the chat to go crazy, put it in the comments in the chat just to make it go nuts. Kyle, any updates in Kyle that you're allowed to share?
No, the trial scheduled for November, and that's the scope of it for now. Okay. And so and then I'll be at the after party at our locals. We do a little a live chat. There's people live chatting there now, and I'll be there for about 30 minutes. About 10 minutes after this ends, I'll be over there for about 30 minutes or so at vivabarneslaw.locals.com.
I put the link in, and there was one other thing. Oh, the Don Lemon lawsuit. We'll get to it next week.
We'll get to it next week. I will be appearing in a case suing Don Lemon. So that'll be the announcement exclusive to this audience, but right. I'll have more. There may be more details in it next week. And next week we'll get to SEC v. Ripple, Odyssey, Library, the attempts of the SEC to frighteningly try to classify a lot of blockchain as securities and basically run them out of business. So, we'll get into that next week, though. It's its own topic.
Yeah, and it's good. It's also better to keep it separate from everything we discussed tonight. And in this week, I'll do a video on the Don Lemon, the proceedings that exist up to now, because it's an interesting read. It's not news for anybody who's known the story, but we'll see. I'll get everyone's appetite whet for next week, because there will be no love lost in this crowd for Don Lemon getting sued. Okay, Robert, give us some final words, and then we're going to tune it up. But before then, everybody in the chat, thank you for the support. Thank you for being here. Thank you for the comments. Robert, words of wisdom and encouragement for the week to come.
I mean, I think from an evidence perspective, the defense is doing a decent job, and the judge has been very fair in that case. And if that jury may ultimately affirm people's confidence, and if it does, I believe it will be African-American male jurors who lead an acquittal jury if there's any acquittals in that case. And that will be cognitive dissonance for aspects of the left, but it will be a reassurance of the capability of our legal system otherwise.
Excellent. All right. Stick around, Robert. We'll say our proper goodbyes. Everybody out there, enjoy what is left of the weekend. I say happy Easter, but have a meaningful Easter. And hopefully you're allowed to celebrate it the way you want to. So enjoy.